Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. We're scheduled for a 10 a.m. hearing this morning. We are having severe technical difficulties. I wanted to go on the record and broadcast just to let everyone joining in know that we have not forgot about you, and we always want to start on time, but unfortunately at this moment we're having severe technical difficulties and we're trying to work through them. If you would uh, give us until about 10:20, and hopefully we can come back on with all of our issues resolved. Thank you. Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. We are here today, March the 9th at 10:20 a.m. to hear competitive procurement of renewable energy. Hearing is a docket of 2019-365E. Before we call this hearing to order, please join me with a brief moment of silence. All right. I guess one of the benefits of the moment of silence is that we can tell when someone's microphone is not muted. I think someone may be closing file cabinets or reorganizing furniture. If everyone could please mute their microphone. Thank you. All right, General Counsel Wessinger Hill, if you could read the docket.
Thank you, Mr. Chairman and Commissioners. This proceeding before the Public Service Commission, docket number 2019-365E, regarding the exploration of a South Carolina competitive procurement program for the competitive procurement of energy and capacity from solar and other renewable energy facilities by an electric utility as allowed by South Carolina Code Section 58-41-20E2. This matter was originally scheduled for hearing on Thursday, December 10th, 2020, but by Commission Order 2020-779, the virtual hearing was rescheduled for today. Mr. Chairman and Commissioners, there are two preliminary matters to address when you're ready. Otherwise, the docket is in order.
Okay, so what we're going to do, we're going to, before we address those preliminary issues, let's take roll. Present in the hearing room, we have Commissioner Powers, Commissioner Thomas, Vice Chair Belzer, and Chairman Williams. Joining us virtually, we have Commissioner Caston, Commissioner Williams, and Commissioner Urban. General Counsel Wessinger Hill, if you would proceed with the preliminary matters, let's address those.
Yes, sir, Mr. Chairman. The first preliminary matter is with regard to the name change of South Carolina Solar Business Alliance Incorporated to Carolina's Clean Energy Business Association. There's a motion that is pending before the commission with regard to this.
Okay, thank you, General Counsel Wessinger Hill. I beg your indulgence, 1 second.
Mr. Witt.
Yes.
Would you please mute your mic? Thank you.
Okay, thank you very much. All right, General Counsel Wessinger Hill.
The other matter for consideration, Mr. Chairman, is the Pro Hoc Vici application of John D. Burns with regard to and on behalf of South Carolina Solar Business Alliance Incorporated, now known as Carolina Clean Business Energy Association.
Okay, I am reviewing a letter from the South Carolina Supreme Court, the Supreme Court of South Carolina, dated March 4th, 2021, signed by the Deputy Clerk of Bar Admissions that certified that the filing fee for the applicant has been paid. All his paperwork is in order, and he can appear before the commission as I grant his motion for Pro Hoc Vici. All right, and the next item.
Thank you, Mr. Chairman. Those are all the preliminary matters.
Well, did we get to the I think the name of the intervener, formerly known as or currently known as the South Carolina Solar Business Alliance Incorporated?
Yes, sir, but I'm not sure if you actually ruled on that or not, but yes,
no,
sir.
I did not. So I think what the ask is for them to be referred to as their new name under their merger, Carolina's Clean Energy Business Association. Is that correct?
Yes, sir.
Okay, and that will help assist us in this record to make sure everyone knows who we're referring to.
Yes,
Is
sir,
that
Mr.
correct?
Chairman.
Okay. And Mr. Witt, do you object to us moving forward in this hearing with Carolina's Clean Energy Business Association as opposed to South Carolina Solar Business Alliance?
We do not object. In fact, we appreciate you taking care of that and taking care of Mr. Burns Pro Hoc Vici. Those are both fine.
Thank you, sir. Okay. General Counsel Wessinger Hill, is there anything else?
No, sir, Your Honor.
Okay. So let's call the parties to make sure we know who's with us. And this cast of characters is in alphabetical order, and we're going to start. We're going to start with Dominion.
Good morning, Mr. Chairman and members of the commission. My name is Chad Burgess, and with me today is Matthew Gissendaner. He and I are in-house corporate counsel for Dominion Energy South Carolina, and we also have with us Ashley Cooper and William Middleton from the law firm of Parker Poe, who serve as the company's outside counsel, and together we represent the company in this proceeding. Thank you.
Okay, thank you, gentlemen, ladies and gentlemen. With Dominion, Duke Energy Carolinas LLC, Duke Energy Progress LLC.
Good morning, Mr. Chairman, Commissioners. It's nice to see you this morning. I'm Rebecca Doolin. I'm in-house corporate counsel for Duke Energy Carolinas and Duke Energy Progress. And you just get me today, so I'm happy to be with you. Thank you.
Happy to have you, Ms. Doolin. Good to see you again. All right. Carolinas Clean Energy Business Association.
Mr. Chairman, I'm Richard Witt from the Witt Law Firm. Also appearing today is Ben Snowden from the law firm Kilpatrick Townsend. Also appearing today for SECEBA is John Burns, who is the general counsel for SECEBA.
All right. Thank you, sir. Cypress Creek Renewables LLC.
Richard Witt from the Witt Law Firm for Cypress.
Okay, thank you, sir. Ecoplexus Incorporated.
Richard Witt once again for Ecoplexus.
Southern Current LLC.
Yes, Mr. Chairman, Richard Witt for Southern Current.
All right. Johnson Development Associates Incorporated.
Yes, sir, Mr. Chairman. Weston Adams with Nelson Mullins for Johnson Development. I've got my partner, Court Walsh, with me today. I'll be here just for a bit this morning, but Court will be here for the entire hearing.
Thank you, sir. Good to see you again.
Yes,
South Carolina Coastal Conservation League and Southern Alliance for Clean Energy.
Yes, good morning, Mr. Chairman, members of the commission. My name is Kate Lee Mixon, here today representing South Carolina Coastal Conservation League and the Southern Alliance for Clean Energy, and I appreciate the opportunity to be here today.
Good to see you again, Ms. Mixon. I'll tell you, we've been having so many hearings. I feel like I'm getting to know you all a little bit.
Yep.
All right. South Carolina Department of Consumer Affairs. I understand that they have been noticed, but have not appeared or participated in this docket. And then we also have the ASEAN Group LLC, who initially filed that they would participate. I think I have a letter dated January 21, 2020, that they would participate, but since that time have failed to do so, so they are not present. Last but certainly not least, the Office of Regulatory Staff.
Good morning, Mr. Chairman and members of the commission. This is Chris Huber, and I will be here today on behalf of the Office of Regulatory Staff.
Mr. Huber, good to see you again today.
Thank you, Mr. Chairman.
All right, so now we have the parties in line. If there's nothing else that we need to discuss before we begin, Dominion, would you call your first witness?
Thank you, Mr. Chairman. This is Ashley Cooper on behalf of Dominion Energy, and Dominion Energy South Carolina calls Daniel F. Cassis to the stand.
Mr. Cassis, if you would take the witness stand, pause for a brief moment, and allow the court reporter to swear you in, we would greatly appreciate it, sir.
Mr. Cassis, give us just one moment. Mr. Cassis, if you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much.
Thank you. Mr. Cassis, please state your name for the record.
Daniel F. Cassis,
And by whom are you employed and in what capacity?
Dominion Energy, South Carolina. I'm the General Manager of Strategic Partnerships and Renewable Energy.
Have you prepared, caused to be prepared under your supervision, direct testimony of 14 pages that was previously filed with the Commission on February 22nd, 2021 in this docket?
I have.
Do you have any changes or additions to your pre-filed direct testimony?
I have no changes or additions.
And if I asked you the same questions here today, would your answers be the same?
They would be the same.
Mr. Chairman, at this time, I move that the pre-filed direct testimony of Mr. Cassis be admitted into the record as if given orally from the stand.
The pre-filed direct testimony of Mr. Cassis will be entered into the record as if given orally from the stand.
And Mr. Cassis, have you prepared a summary of your direct testimony?
I have prepared a summary.
Would you please deliver it at this time?
Good morning, Chairman Williams and members of the Commission. My name is Danny Cassis. I provided direct testimony in this docket on behalf of Dominion Energy South Carolina on February 22nd, 2021. And I respectfully request to provide the Commission with this summary of the same. I'm the General Manager of Strategic Partnerships and Renewable Energy for Dominion Energy South Carolina, DESC. In that role, I oversee customer-facing solar, all renewable energy initiatives for DESC. The purpose of my direct testimony is to provide the Commission with a background of DESC's commitment to renewable energy and its success in increasing the amount of renewable energy today. Introducing other witnesses who will testify on behalf of DESC and provide a high-level overview of the complexities and utility-specific nuances inherent to any CPRE process. DESC's commitment to renewable energy has been well publicized and outlined for this Commission in numerous dockets. Currently, DESC has approximately 1,000 megawatts of solar generation on its system, with an additional 4,000 megawatts pending in the interconnection queue. A substantial majority of that capacity arises from utility scale solar, which saw an increase of 75% in year-over-year capacity from the summer of 2019 to the summer of 2020. These figures place DESC among the leaders in distributed solar, not only in the state, but in the Southeast. This growth was largely driven by PURPA, which requires DESC to purchase renewable generation from qualifying facilities without regard for location or need, an obligation that obviously presents challenges given that purchases under PURPA do not necessarily account for cost effectiveness or policy objectives. However, the CPRE process, if implemented correctly, can advance cost-effective policy objectives, procure power at rates lower than would otherwise be paid by the utility under PURPA, address discrete needs, or deploy emerging technology rather than simply piling on more capacity of a fuel source that already comprises a significant amount of the overall generation portfolio. Given these complex issues, DESC engaged Guidehouse, a third-party consulting firm. Witness Kojak is a director with Guidehouse and will provide the Commission with a broad overview of the various types of CPRE programs. Witness Mans is also a director with Guidehouse, and she will provide the Commission with an overview of other aspects of utility operations that are impacted by the CPRE process, such as interconnection. Together, the testimony presented on behalf of DESC will fulfill the Commission's goal in this generic docket to frame a preliminary discussion of CPRE in its various forms. DESC further agrees with the Commission's goal in this docket and understands that any utility-specific decisions should be fully vetted and considered outside of this generic preliminary docket. This need to account for utility-specific characteristics such as generation portfolio, load profile, and the distribution and transmission systems is bolstered by the plain language of Act 62, which references CPRE programs specific to each area's utilities balancing authority area. Additionally, the implementation of a CPRE program not only involves questions specific to a utility's particular attributes, but must also account for certain non-price factors such as reliability and operating experience. As such, Witness Kojak provides the following best examples and recommendations on behalf of DESC. CPREs should be driven by resource needs and plans identified in the utility IRP process. CPREs should be open to all technologies that meet operational, reliability, and other identified resource requirements unless otherwise driven by specific policy goals. CPREs should encourage wide participation to promote competition and maximize customer benefit. CPREs should also include appropriate oversight to include fairness and transparency. CPRE evaluations should consider all system costs and benefits to ensure that the projects are providing net benefits to utility customers. I thank the Commission for its time, and this concludes the summary of my direct testimony.
Thank you, Mr. Cassis. Have you also prepared a cause to be prepared under your supervision responsive testimony of 8 pages that was previously filed with the Commission on March 1st, 2021 in this document?
I have.
Do you have any changes or additions to your pre-filed responsive testimony?
I have no changes or additions.
If I ask you the same questions here today, would your answers be the same?
They would be the same.
Mr. Chairman, at this time, I move that the pre-filed responsive testimony of Mr. Cassis be admitted into the record as if given orally from the stand.
The pre-filed responsive testimony of Mr. Cassis will be entered into the record as if given orally from the stand.
Thank you. Mr. Cassis, have you prepared a summary of your responsive testimony?
I have prepared a summary of my responsive testimony.
Would you please deliver it at this time?
In my responsive testimony, I reiterate the purpose of this generic docket and highlight several areas of agreement among and between DESC and witnesses Brown and Searcy. The purpose of this generic docket, this generic proceeding, was outlined clearly by Commission Order number 2020-779, which is for the exploration of a South Carolina competitive procurement program. In furtherance of this goal, the Commission enumerated several specific items to be covered by the parties in this preliminary docket, which ranges from challenges and costs of the CPRE process to various impacts to ratepayers arising from the CPRE process. The testimony in this docket reveals several areas of agreement on these topics among DESC and several other witnesses. For example, Duke Witness Brown draws upon his experience with the CPRE process in North Carolina to explain the time and the financial commitment that is necessarily involved in implementing any CPRE process. Duke Witness Brown describes the implementation of a CPRE process as time-consuming and requiring a number of decisions. Underscoring this point, Witness Brown notes that the implementation of the CPRE process in North Carolina was undertaken via the legislative process that took place over approximately 7 months and involved several months of discussion and negotiations. Witness Searcy also outlines several points that are echoed in DESC's testimony. For example, Witness Searcy highlights the importance of considering provisions for managing energy curtailment for systems with non-trivial levels of solar on the grid. Witness Searcy notes that this type of flexibility in design elements is crucial to meet specific goals of the jurisdiction, and that a well-informed IRP can inform design by identifying specific needs of the utility. Witness Searcy goes on to note that the due diligence in carrying out any CPRE process is challenging and carries a realization risk, meaning that there is always the chance that even with well-implemented CPRE process, certain projects may fail. Despite the many points of agreement between DESC and Witness Searcy's recommendation to implement a near-term process to gain experience for a more complex process is misguided and outside the scope of this proceeding. Implementing a near-term process to simply gain experience would ignore identified needs, if any, in an IRP and result in premature costs to ratepayers. Lastly, I briefly discussed the testimony of Witness Levitas, which is premature and outside the scope of this generic docket as outlined by the Commission. I thank the Commission for its time, and this concludes the summary of my responsive testimony.
Thank you, Mr. Cassis. Mr. Chairman, Mr. Cassis is available for cross-examination by other parties and questioning by the Commission.
All right, thank you very much. Questions from the Duke companies?
No questions for this witness, Mr. Chairman.
Questions from Carolina's Clean Energy Business Association?
Yes, Mr. Chairman, we do have some questions.
Please proceed.
Okay. Thank you, sir. Mr. Cassis, good morning. It's good to see you.
Good morning.
Mr. Cassis, Dominion's position is that the Commission should not, in this docket, order either Duke or Dominion to engage in any procurement of renewables. Is that right?
So in reading the actual order for the generic docket, it has outlined, I believe, 6 points that are to be provide information in the generic docket. And so the actual the references to the utilities ultimately to make determinations within the utilities balancing authority or area. So it would be specific to a utility.
Okay, so let me ask the question again. So it's Dominion's position that the commission should not, in this docket, order Duke or Dominion to engage in any procurement. Is that right?
Not in a generic docket, that's correct.
Okay. Is it also Dominion's position that the commission shouldn't establish any process or guidelines for procurements at all in this docket?
Well, I think what we have provided, and Witness Kojak will do this, but he's provided some specific directions, which I think I actually repeated, but he's got our best practices and our things to be considered. So those are included in our recommendations for the benefit of the commission.
Well, as I read Mr. Kojak's testimony, there are several instances where he says it's premature for the commission to adopt any guidelines, or the commission should not adopt any guidelines on particular issues. Is that a fair characterization of his testimony?
Yeah, I think what he's saying, and he will say it, I'm sure, during his testimony, but competitive procurement is very specific to your balancing authority and the specific needs. There should be a need. And if there's a need that's identified, tie competitive procurement for renewable energy to a specific need.
Well, setting aside the question of whether to engage in procurement for a particular utility at a particular time, is it Dominion's position that in this docket, the commission should not issue an order or should not issue any guidelines or ground rules for competitive procurements?
Yeah, we're taking the position that this is information, it's a generic docket, and they could provide guidelines, but we want the specific guidelines to relate to our balancing authority and specifically to a need.
So you'd agree that it would be appropriate for the commission to issue general guidelines in this docket?
Around the specific needs of the utility, correct.
Okay, I'm sorry, I'm not sure I understood that. So are you agreeing that it would be appropriate in this docket to issue some general guidelines, but that specific, more granular guidelines should be deferred to the general dockets? I'm sorry, the utility-specific dockets?
Mr. Chairman, this is Ashley Cooper, counsel for Dominion Energy. We'd object. This is asked and answered. Perhaps Mr. Snowden might like to clarify what he means by guidelines. This witness has attempted to answer this question several times. Maybe he could be more specific. I've tried not to object until now, but I feel the need to. I see this going in a repetitive cycle here.
Well, Mr. Cass has certainly given me a response, but I'm not sure I've gotten an answer. But I will try to. I'll try to be more clear about that.
All right, please proceed.
So, Mr. Cassis, okay, yeah, I'm reformulating my question. Well, so Mr. Levitas, for example, in his testimony, has included a set of proposed guidelines for competitive procurement. So, are you aware of that?
I am.
Okay, and is it the company's position that those sort of guidelines would not be appropriate to be approved in this commission? I'm sorry, in this docket.
Yeah, so I believe Mr. Levitas, Witness Levitas, had guidelines that were from another jurisdiction. And I think that's important to note that you wouldn't necessarily overlay guidelines from another jurisdiction. You would want to be very specific about what you were solving for or what need you were identifying, and then how those would be applied. So in many jurisdictions, there are guidelines, but I would want, and I think the company would want, guidelines that were specific to our balancing authority area.
So when you say guidelines from another jurisdiction, you are referring to the guidelines that Duke Energy Progress in Carolinas have followed for implementing their CPRE program in North Carolina and also in South Carolina. Is that right?
That's correct.
Okay. So is it your position that, or the company's position rather, that the commission should not in this docket create any programs for the procurement of renewable resources?
Yeah, not in the generic document. I think it actually, even in the order it references, moving to the utilities balancing authority area. And I think that strikes to the concept of specifically addressing the utility and then how it operates in its specific supply within its balancing area.
Well, Mr. Cassis, are you familiar with the provisions of Act 62 as they relate to competitive procurements?
Yeah, I am.
Okay, so specifically, we're talking about Code Section 584120E2, is that right?
That's correct.
Okay, and subject to check, would you agree that that provision reads, the commission is authorized to open a generic docket for the purposes of creating programs for the competitive procurement of energy and capacity for renewable energy facilities by an electrical utility within the utilities balancing authority area if the commission determines such action to be in the public interest? Is that how that reads?
Yeah, within the utilities balancing authority area, correct.
Okay. But it does say open it. Right, so, but it does say open a generic docket for the purposes of creating programs for the competitive procurement of energy. Is that right?
It says open a generic docket for the purposes of creating programs, and then it actually enumerates the six things that the commission needs to hear or wants the parties to provide information on.
Mm-hmm. Oh, so you're referring to the order, not the statute?
Correct. Yes.
Okay. And is it correct that in the order, the commission provides non-exclusive lists of topics that the parties should provide comments on?
Yeah, it provides 6 items, and then but it also says it's not limited to those.
Okay, thank you. So despite the fact that the statute says the generic docket is for the purpose of creating programs for the procurement of energy and capacity for renewable resources, you do not believe that this docket is for the creation of programs for competitive procurement?
Again, I go back to the words utility balancing authority area. If the commission, I'm just reading the literal words of the act. And I think that's very, very, very important. I think they're the utility and the ultimate responsibility to provide reliable service within their balancing authority. It was clearly contemplated in that section of the law.
So, Mr. Cassis, what do you think the commission should do in this docket?
Accept the information and take the information that's provided by all the witnesses. And then they have the ability then to make determinations based on public interest.
So what determinations should the commission make in this docket?
I'm not going to presume to know what the commission should do. I think one, they should act in the public interest. One, they should ensure that systems operate reliably. They should be informed by other plans that the utility have filed. But I understand a generic docket to be opened for the purposes of gaining information, but it is specific to the utilities balancing authority area.
So you think this docket is, speaking specifically, Dominion would not recommend the commission actually do anything specific in this docket, just gather information?
No, I think we make some recommendations.
Counsel for Dominion, I think Mr. Cassis has answered these questions. They're asked and answered, so I object on the grounds asked and answered. It's also outside the scope of his direct testimony.
Well, again, Mr. Cassis has given me sort of general high-level answers about what the commission should be keeping in mind, but I don't believe that I've gotten an answer to the question of what it is Dominion thinks the commission should actually do coming out of this docket. So I'm simply trying to get an answer on that question.
Thank you for your objection, Mr. Cooper. The objection is overruled.
So again, Mr. Cassis, I'll try to keep the question brief and move on. is it your view that the commission, or is it the company's view that the commission in this docket should simply be gathering information and that it should not actually do anything or issue any particular orders coming out of this docket?
I don't have an opinion. I think we were required in the generic docket to provide appropriate information and answer issues such as best practices and then challenges and costs. So I think and I think specifically our position is always about, is there a need? And if there's a need, is there a way to reliably address that need? But we think it's tied to a need. So I think that's up to the discretion of the commission.
So it is the company's view, as you said, that competitive procurement of resources should be driven by resource needs that are identified in the IRP. Is that right?
That's correct.
And Dominion's IRP is currently being litigated before the commission, correct?
Yeah, in February, we filed a modified IRP. So that's before the commission.
And that's still subject to comment by interested parties.
That's correct.
And one of the issues that was raised by interveners in the Dominion IRP docket is whether the preferred resource plan should include near-term procurement of solar resources. Is that right?
I believe that's accurate.
So, Mr. Cassis, if the IRP that is ultimately approved by the commission calls for near-term procurement of resources, you'd agree that it would be appropriate to proceed with the procurement then, wouldn't it?
You're asking me if by the way, that's not the plan that's been filed. But if the plan is different than the plan that's provided in the modified, would that be a path? Then
yes, if the plan, I'm sorry, go ahead.
Yeah, it's certainly possible. That's within the commission's purview.
Okay, so when you say it's possible, are you agreeing that if the preferred resource plan approved by the commission includes near-term procurement of renewable resources, it would be appropriate to proceed with a procurement?
Procurement has the potential, as I think we described with our witnesses, it has the potential, if properly established and set up, it has the ability to provide some benefit.
So you're saying it might not be appropriate to proceed with the procurement, even if the IRP as approved by the commission includes near-term procurement?
I would say always, yeah, excuse me, I'm sorry. I did not let you finish your question.
No, I finished it.
Yeah, I would say in the context of an analysis on the utilities balancing authority, I think that would be probably an important point to help make that determination. So procurement for the sake of procurement may not provide a benefit. I think it has to be comprehensively evaluated.
Understood, but I want to go back to what Dominion's witnesses have testified to about the IRP necessarily driving procurement decisions. If the IRP that the commission approves says go forth and procure or go forth and put some number of megawatts of renewables on the system in 2023, would it then be appropriate to set up a procurement to get those resources?
I think that is a way, and I think, again, with our other witnesses, we are describing a number of things that I think need to be included in a process like that.
So if, for example, the preferred plan calls for procurement of resources that would come online in, say, 2023 or 2024, wouldn't it make sense to go ahead and set up a procurement structure or program so we can achieve that goal?
Mr. Chairman, this is Ashley Cooper, counsel for Dominion. Again, I object to this line of questioning. We're now into the weeds on the Dominion IRP process. As council's acknowledged, there's a separate docket where that's currently being considered. I've let council ask several questions along this topic, although I believe all of them have been outside the scope of this generic docket. So I object.
Mr. Cassis and Mr. Kojak both testify a good deal about the need for IRPs to drive procurement decisions. And so I am, and also about what should and should not be done in this docket. So these questions are definitely relevant to those issues that are raised in the testimony.
Well, I agree, Mr. Chairman, that they do testify about generically the need to consult an IRP because they're helping this commission develop a record and they're helping this commission understand a CPRE process. They're not testifying to the specifics of Dominion's IRP process, and they're not testifying to some future document that would examine a specific CPRE adopted for either the utilities.
Mr. Cooper, would you not agree that the witnesses, this witness particular, Mr. Cassis, excuse me, testified to the IRP in his direct testimony?
I think he generically referred to the need, Mr. Chairman, and he's testifying in terms of a best practice, saying there are a number of things that impact a CPRE process. So, for example, the coordination with an IRP would be important. I think that witness Kojak and witness Kojak can testify to this as well, but what the witnesses are doing is telling you in a generic manner across any jurisdiction, this would be something that as you explore how CPREs are structured and how they're implemented, this is something to take into account. I do not believe, Mr. Chairman, that Mr. Cassis or Mr. Kojak has testified in detail about the pending IRP that's been filed in a separate docket.
Thank you for your motion, Mr. Cooper. I overrule your objection. I do believe that the IRP is within the scope of the direct. And I mean, and I know you know this as well, cross-examination is broad and not limited. As long as the information is relevant. Please continue.
Thank you, Mr. Chairman. So, Mr. Cassis, going back to my question, if the preferred plan in the IRP approved by the Commission calls for the procurement of resources that would come online in 2023 or 2024, wouldn't it make sense to go ahead and set up a procurement structure starting now so that we can actually achieve that goal?
The structure, it's possible, but what you'd want to make sure you did was ensure that structure and the guidelines were in place and they were specific to the balancing authority, the balancing area authority. I think that's actually the most important point, is that it shouldn't be just a here's competitive procurement and here's the goal. It needs to be very structured and it needs to be well thought out in terms of doing. So if that can be done in a short period of time, which I don't think other witnesses have concluded already that it's going to take a little time, I think that's important.
So, Mr. Cassis, if it's going to take a little time to set up those structures, don't you agree that we should be moving forward now rather than deferring into decisions about structure to some indefinite time in the future?
No, I think actually in my testimony, it describes it maybe being a little bit premature. I think you want to know the need, and then you sync those concepts up if there is certainly a need.
Well, so, Mr. Cassis, you wouldn't want to be in a position of the approved IRP calling for resources to be added in 2023 and not to be able to achieve that because we simply haven't started setting up a procurement process, would you?
I would want the procurement process to be effective and efficient. I wouldn't want to use a lot of resources that, burdened the process administratively. I'd want it to be properly aligned.
So you would rather the commission simply wait to do anything until after the resource needs are identified?
there needs to be a specific need. Those are best practices that I think we identify, that once the need gets identified, that then becomes the information that drives the process.
And so you would rather all of the sort of high-level issues that are involved in procurement, such as utility participation or transparency, you would rather those issues all be decided separately in utility-specific dockets?
No, that's not what I said. Today, because we're in the generic docket, we're providing best practices, but I think you do tie it ultimately to this need, so that you're not proceeding in a way that then actually doesn't have a specific need. I don't even know how we would, in an advanced process at high level, you could provide some guidelines, but in our situation, in our certain balancing area, because we have so much of certain products, such as straight direct solar, that there's going to be some precision, stakeholder process, very careful thought process around the complexities of the resource that could be required.
So it's your view that there are simply no common issues that can be decided by the commission for all utilities, and that all those issues have got to be decided twice or three times?
No, that's not what didn't say that at all. I just said I think the commission is informed by a number of proceedings. The IRP is certainly one, because that ultimately determines or makes a big determination about need. But then in this proceeding, there are guidelines and best practices. I think the commission is well qualified to take that information and then make decisions based on what they hear in those proceedings.
Thank you. So, Mr. Cassis, have you reviewed Mr. Brown's testimony? Is that right?
I have looked over Witness Brown's testimony.
So on page 21 of Mr. Brown's direct testimony, he testifies that even where renewable resources provide little or no capacity, the IRP can select a renewable resource as a potentially economic source of energy. Is that right?
I'm going to take your word. That was what I don't remember exactly.
Okay. Well, feel free to refer to it if you like. Do you agree with Mr. Brown about that?
That renewable resources can provide some value. I want to rephrase. If you rephrase the question.
Sure. As I read Mr. Brown's testimony, he says that even when there's not a specific capacity need to be met, renewable resources can be a potentially economic source of energy on the system.
Yeah, I would agree with that. I think you know the amount of PERP activity we have on our system, so we believe those provide some benefit.
Mm-hmm. And that's because that renewable energy, even in the absence of a capacity need, can potentially displace the energy being produced at a greater expense by existing resources, at least potentially. Would you agree with that?
I wouldn't say at a greater expense. I would say it would have to be less than the existing expense, and that doesn't happen in many cases. It would be an avoided cost, I think would be the metric that you would reference. So if it cost more than avoided, those would be rate impacts. If it was able to provide and adequately evaluated, and it was less than avoided, then it would be ratepayer benefit. But that's a specific and important distinction.
I see. So what you're saying, if I understand it, is that if a renewable resource can deliver energy at below avoided cost, that is potentially an economic benefit for the ratepayers, even if there's no capacity need.
That's correct. If avoided cost is properly calculated, and that is, yep.
So, Mr. Cassis, in your direct testimony on page 11, you testified that a CPRE process can help to diversify the utility's renewable fuel sources. Is that right? And feel free to take a minute to turn to that.
Yep, that's correct.
Okay. And you would agree that diversity of generation sources is a good thing, wouldn't you?
Yeah, diversity in generation resources is a good thing. That's correct.
Mr. Cassis, do you have a copy of Mr. Levitis's direct testimony and exhibits?
I do. It's I'll move it out. Let me move this out the way and get this.
Sorry. And I'm looking at Exhibit 6 to Mr. Levitis's direct testimony.
So I am in close to Mr. Levitis's testimony. Of course, as you know, he provided it's not a book. I would, it's multiple volumes of information from jurisdictions that might not match up with South Carolina, but I've got it.
Okay, understood. So do you have Exhibit 6? Can you find that?
Yeah, I'm going to assume it's in the back, Counselor.
Well, this is, if you recognize, if it's familiar to you, this is a summary of electrical generation data for South Carolina utilities that's prepared by the South Carolina Energy Office. And I can attempt, Mr. Chairman, I can attempt to share that if it would be helpful, or let Mr. Cassis find that.
If you can share it now, please.
Okay. All right, is that, can you all see that now?
Yeah, Counselor, I can see it. If you can make it just a little bit bigger.
I can sure try.
Yep. Okay, that's great. Thank you.
Okay,
yep.
Great. Can you see Table 1 on here?
Yeah, correct.
Oh, if I haven't gone too far past. Okay. And just to back up, would you agree that this is a summary of electrical generation data in South Carolina prepared by the South Carolina Energy Office?
Yeah, it's South Carolina, but yeah, and there's Dominion. The Table 1 is actually Dominion.
Yes. So yeah, Table 1 summarizes the megawatt hours generated on Dominion system in 2019 by source. Is that right?
That's correct.
Okay. So it says coal 24%, nuclear 23%, natural gas 50%. And then you see below where it says that the total amount of company owned and purchased solar is 869,361 megawatt hours out of a total of 23,719,708. Is that right?
Yeah, on this, that shows the megawatt hours produced. It doesn't show the nameplate or makes no representation about the profile and the system and the balancing authority area, but that's I do see the chart.
Okay, thank you. And would you agree, subject to check, that this 869,000 and some change number represents about 3.5% of Dominion's total generation in 2019?
Yeah, I would say it's outdated because you've got 20 data and there's now 1,000 megawatts of solar, but I would say that, of course, as you know, the capacity factor of solar is not in a range that is, it's an adequacy mechanism correction, but it doesn't produce all the time. So it's not an around-the-clock resource. So you can have a lot of it, but you just can't have a lot of it at the same time. So that's the limitation, or I guess the story behind the story, if you will.
And Mr. Cassis, with respect to diversity of generation, would you agree that solar plus storage facilities have a potentially very different generation profile than solar without storage?
Yes, it can, if properly, again, if properly contracted for, it can provide a different profile. So there's the ability to shift some of the energy to time periods where the traditional solar profile doesn't pancake on top of what already exists.
So adding storage can really add to that capacity factor for solar. Is that right?
If it can be financed, it could be. Yeah.
Thank you.
And I would add, it's not the only way to balance a system, is to just to couple it with PV.
Mm-hmm. You can also, for example, add more natural gas-fired units. Is that right?
No, or you could have standalone storage, which would then provide the equivalency of, it's essentially modeled just like pumped hydro. It could then allow maybe even greater flexibility on dispatch rather than just coupling it with one device.
Understood. So adding storage resources can effectively increase the capacity factor for intermittent resources like solar. Is that right?
Yeah, there's two models. I mean, one is to couple it specifically with PV, but there's also the consideration to have it as a system asset, which can then help not only PV, but help the overall total balancing authority area.
Understood. Thank you. I'm going to stop sharing this now. Mr. Cassis, were you aware that in May of 2020, the General Assembly explicitly permitted Santee Cooper to go out and competitively procure up to 500 megawatts of solar?
Yeah, I am. I talked to a lot of solar developers who participated in that process. So yeah, I am.
And is it your understanding that 500 megawatts was based on Santee's IRP?
I don't know what they based it on, and to be clearly honest, most of the feedback I got was from solar developers who participated in the process. So that's where most of my information is coming from. I don't know what they utilized to inform them or how they determine their need.
Thank you. Are you aware that, or would you agree that now, less than a year after the General Assembly authorized it, Santee has successfully completed that solar procurement?
So I'm unaware of any projects that are commercially completed. As I said, most of the feedback I got were from reputable solar developers who had issues, quite frankly, with some of the pricing that actually appeared to have been the lowest cost providing. It was kind of this realization risk that witness Cersei. So I don't know for sure if any of that resource ever got built, or is it getting built. I think it was priced.
Thank you. Mr. Cassis, on page 13, I'm looking at page 13 of your direct testimony. You referenced several best practices, and you've talked about this before, several best practices that Mr. Kojak identifies in his testimony. Do you see that?
Yep. Counselor, which testimony are you referring to?
I'm sorry, this is your direct testimony, page 13.
Okay.
So you relate several best practices that Mr. Kojak mentions in his testimony. Is that right?
Yeah, those are the 5 things that I repeat that are actually in witness Kojak's. I refer to those as best practices.
Understood. And one of those, number 3, is that CPRE should encourage wide participation to promote competition and maximize consumer benefit. Is that right?
That's correct.
And would you agree that this would be an element in determining whether a competitive solicitation program is in the public interest?
Yeah, the CPRE process should encourage wide participation. Yeah, it should, and a matter of fact, it shouldn't be, make it as unlimited. The more competition, I think, the better. And again, assuming there's a need, then I agree.
And can't the commission start off in designing procedures to encourage wide participation now, in the event that a procurement is called for?
I mean, the short answer is they could, but I think it really depends on the specifics. So could there be something they could do to encourage wide participation? I think you probably read my direct testimony. You know, there's 4,000 megawatts of solar already in the queue in South Carolina. And so they're continuing ongoing negotiations. So I would say that 3 is important, or I wouldn't have listed it. But if there's something that could be done to, I guess, encourage wider participation, does that mean 10,000 megawatts of potential projects on a system that operates only at 2,000 on a minimum day? I don't know that that actually physically works.
Well, just to be clear, when you're talking about participation, that does not dictate the size of the ultimate procurement, does it? And you could have 10,000 megawatts of projects participate, but only select 200 of them. Isn't that right?
Yeah, actually, to encourage wide participation isn't. We, to the extent that there can be more participants in the market, with more resources. If today there are 3 major participants, and it increases it to 6, and it does encourage them to then compete with the existing 3 entities that are certainly doing most of the work. I'm comfortable. I would support that, including storage integrators too. Absolutely.
So looking at item 4 here, you said that CPREs should include appropriate oversight to ensure fairness and transparency. Is that right?
Yeah, that's correct.
Okay. And you'd agree that this is also an important element in ensuring that a competitive procurement is in the public interest, isn't it?
Yes. Again, I'm not an expert. I think witness Kojak provides testimony as to how that could be, how that could play out, whether it's an administrator or what exact administrative form. But I obviously support that concept.
Mm-hmm. And this would be appropriate regardless of what the resource needs are, wouldn't it?
That's correct.
Okay. And it should be true regardless of what utility is doing the procurement, shouldn't it?
Council, repeat that question.
Well, it is the case that a CPRE should include appropriate oversight to ensure fairness and transparency, regardless of what utility is doing the procurement, right?
Yeah, I agree. Yes.
Right. So is there any reason for the commission to wait to consider how to implement this best practice?
It just seems misaligned to me with respect to the determination of a need. I guess you could, but I mean, it seemed like that wouldn't necessarily be the best use of resources. Personally, I would rather spend our resources continuing to currently negotiate, for instance, PV plus storage contracts, knowing that those are much more near term. But I guess we could spend time, we could appropriate resources to that to support it.
Thank you. Mr. Cassis, you've reviewed Mr. Levitis's direct testimony, haven't you?
I've looked at it. Like I said, it was fairly long. So he has a common theme. I understand most of it.
And as you understand it, Mr. Levitas, as an exhibit to his testimony, provides a set of high-level guidelines for running procurements for renewables in South Carolina. Is that right?
Yeah, and I'm turning to his testimony now.
Okay. And we don't need to get into details, but that's an exhibit SJL 11, isn't it?
I think that's correct. That's right. Yeah.
And Mr. Levitas testifies that his proposed guidelines are based heavily on the guidelines for the North Carolina CPRE program that has been run by Duke. Is that right?
I would say it essentially is informed by what happened in that jurisdiction. Yes.
And would you agree that thus far the administration of that CPRE program has been relatively successful?
I would say yes, but I would condition it with it was implemented at a time in a way to satisfy a certain need. I mean, there was essentially obligations, must-take obligations for a higher priced resource. And I think Witness Brown probably speaks to this in his testimony, but it was utilized at a time in a way to address a specific need that worked to the benefit of the parties.
Understood. But with the understanding that the need which drove the North Carolina CPRE process is a bit different than the needs we're talking about here, the ones identified by the IRP, would you agree that the program actually ran pretty smoothly and pretty well?
I would say that based on the feedback that I got, it used a lot of energy and resources. It was complex, but I would have to say that there were some positive benefits. I just don't agree you should necessarily take good, and they may be beneficial, but I don't think you should take everything and then overlay it, for instance, in our balancing area and think it's going to work as effective. That's the distinction that I think I make.
Understood. So you would but in your testimony, and I understand Mr. Kojak mentioned a few things, but in your testimony, you don't provide any specific critique of any of Mr. Levitas's proposed guidelines, do you?
No, only thing I say is that I think it. I think he, for the most part, has advocated for maybe a change in the business model, and I don't think that's the thing that I see in it. Mostly in his testimony. In other words, we did it in North Carolina, and then therefore this is the business model that I think should be the transitional model in South Carolina, and that's what we should do.
Well, Mr. Levitas has got the guidelines that are in that exhibit, SJL 11, don't reference any change in the business model in the Carolinas, do they?
Yeah, I might have been looking at there was another piece, but.
Let's, if you don't mind, let's just look very quickly at that exhibit STL 11. Can you pull that up?
Yeah, Council, if you can pull it up and share it, that'd be great. Only because his testimony was so.
Understood.
Yeah, it had a lot of attachments to it. So I just.
All right. Are you able to see that now where it says direct testimony of Stephen J. Levitas on behalf of the South Carolina Solar Business Alliance, exhibit SJL 11?
Yes. Yeah.
Okay, thank you. I'm going to move forward now. So you've reviewed this exhibit before, right?
Yeah, I have looked at it. That's correct.
Okay, and there's nothing in this exhibit that calls for a change in the business model for utilities in South Carolina, is there?
No, I mean, you're showing me just definitions right now, so.
Okay, well, we can run through here then. Okay, so well, let me ask another question. in your testimony, you don't take issue with any of the specific components of these guidelines that are set forth in Mr. Levitis's exhibit. Is that right?
I hesitate to answer that only because I
Attorney
spent more
Snowden?
time reading his testimony.
Yes, sir.
Would you mind blowing up the document you have shared on your screen?
Sure. Yes, sir. I certainly. I don't mind.
And while we're talking, let me ask you, how much longer do you think you have?
This is my last line of questions, sir.
All righty.
So I've got maybe 5 or 10 minutes tops. Okay. Can you all see that now?
Barely.
Barely. Okay. Sorry, it's big on my screen, but is that better?
Yes, sir, it is.
Okay. Mr. Cassis, in your testimony, though, you don't take any issue with any of the particular elements that are set forth in Mr. Levitis's Exhibit 11, do you?
Without, Counselor, without going through each of the items,
okay.
I would, right. For instance, I see some things in the definition. The definition doesn't actually concern me.
Okay.
But I think in the end of the day, the competitive procurement, the details of it, it's important not to just, I think, overlay something that worked in another jurisdiction. I think it's important to make sure that it works within the jurisdiction for both those who are participating in the market and for those who are, for instance, might be responsible for integrating the resource. So to say everything in that process, I would want to be very specific and look at it in detail to say everything. I would suggest there are good things certainly in the North Carolina process, but I wouldn't want to say let's overlay it or let's overlay one witness's experience from that jurisdiction, which all occurred at a completely different time for a different reason.
Understood. But in your testimony, you do not identify any particular aspects of this this proposal that would be inappropriate for Dominion. It's just that you generally wouldn't want to overlay this model. Is that right?
And I would rely on our witness Kojak, to talk about some of the more distinct best practices, which I think he does.
All right. Thank you, Mr. Cassis. I have no more questions.
Thank you, Counsel.
All right. We're in recess until 11:50. Good afternoon, ladies and gentlemen. We're back before the Public Service Commission of South Carolina in docket number 2019-365E. Let's take roll. In the hearing room, we have Commissioners Powers and Thomas, along with Vice Chair Belzer and Chairman Williams joining us virtually. We have Commissioners Williams, Caston, and Irvin. Before we left, we had just completed cross-examination by Carolina's Clean Energy Business Association. We will move to Cypress Creek Renewables, LLC.
No questions, Mr. Chairman.
Exoplexus and Southern Current.
No questions either. Thank you.
Yes, sir. Johnson Development Associates Incorporated.
No questions, Mr. Chairman.
All right. South Carolina Coastal Conservation League and Southern Alliance for Clean Energy.
Thank you, Mr. Chairman. Excuse me. This is Kate Mixon. We have no questions.
All right, Attorney Mixon. Last but definitely not least, Office of Regulatory Staff.
Thank you, Mr. Chairman. This is Chris Huber. We have no questions for this witness.
Okay. All right, Commissioners, do you have any questions for this witness? Commissioner Powers.
Thank you, Mr. Chairman. Mr. Cassis, I certainly understand your testimony about this being utility specific and need specific. I understand that to some degree, although I would think that as far as what part of the state you live in shouldn't put you where you're treated differently depending on your utility. But my question is, you mentioned jurisdiction a couple of times in your testimony, and it seems everybody has. What do you see as the biggest difference in jurisdiction between South Carolina and North Carolina? I know last week we were trying to compare stuff in other parts of the country, but there seem to be some comparisons here that are local and fairly local, and that we don't have to reinvent the wheel on everything. Could you outline what you see as differences in the two jurisdictions?
Yeah, Commissioner. No, thank you for that question. So the couple of things that I always note, so I think of myself, or I am the system operator. And so one of the things that is very different, for instance, with Duke and with North Carolina system, is the amount of what I would describe as quick responding resource. So they have solar in North Carolina and in part of South Carolina. They dispatch that as a system. Witness Brown can speak to this. But they also have resources which can then respond and react. So for instance, when solar intermittently drops off, or there's over generation or under generation, their system happens to be just currently more responsive. Ours is smaller. It peaks in a winter at about 4,700 megawatts. So on an order of magnitude, it's 7 times smaller than Duke's, 7 or 8 times smaller than Duke's system. So you take the amount of resource that we've already got, and then maybe the lack of current flexibility with additional supply resource, it makes it much harder. So you just don't take something that happened to work at a certain time in one jurisdiction and then lay that over the top of another and say, yeah, this works. I'm a big, I've said this once, I've said it 10 times. Just because policy was done a certain way in North Carolina, I wouldn't necessarily advocate to do it that way in South Carolina. It's a very specific case. With 1,000 megawatts of already renewable solar, you saw the chart and how much of it actually delivers megawatts, because it all generates along that same profile. And I think that's where the real thought process should come in creating anything in a competitive procurement process.
Well, there was somewhere in the testimony that said that securing more solar would not be necessarily the same benefit. Sounds like to me that might be part of the solution to secure large amounts of solar. Was that in your testimony?
No, I don't think I understood your question, Commissioner. Could you repeat that?
Yeah, I think on page 11, you said that a system becomes saturated and will provide less benefit in units of energy, so that there may be some reason not to pursue solar beyond a point. Is that what that means?
Yeah, actually it means that, their concept, direct solar that has the same profile isn't going to be a benefit, or is going to be less benefit. And typically that value gets decremented as you add more and more of that same type of resource. I think there can be different configurations. There's a concept called flexible solar, for instance, where you have to contract for it differently, and it can be backed off in a way that provides some headroom. That's a product that might be something that could work, but you'd want to study it with the entire system. So yeah, the premise of adding more of the same type of resource on top of the same type of resource, it does decrement the benefit.
And in your testimony, going back to page 6, you talked about intermittent solar and required to implement curtailment protocols. Could you explain what your curtailment protocols are and who required you?
Yeah, so, yes, sir. Yes, Commissioner. So just over the course of the last 5 years, we have so many direct solar resources that there are certain periods in time where the inflexibility of that resource requires that we do something different on our system. I give you the example was actually Friday, where the load's rather mild. It's only 2,400 megawatts and dropping, and we've got 800 or 900 megawatts of solar. So at that point in time, we don't have a place to put it. So by our agreed upon stakeholder protocols for curtailment, the last 3 projects are approximately 200 megawatts. We literally curtail those. We ask those to come off, so nobody benefits from that clean energy because it doesn't deliver to the system. And then we have to essentially respond as the integrator with other assets to back those down to make sure that we're not overgenerating. So if we don't have a place to put it, if we can't pump it through our hydro facility and utilize it there, we have to curtail it.
Is that something that more storage would help, and by the curtailment, doesn't it have a negative effect on the solar customer?
Well, so the seller in that contract, is not getting what they would expect to be compensated. But it wasn't as if these weren't conditions that we clearly pointed out to these entities in the very beginning. We warned them of the risk of potential curtailment. Your point on storage is a good point. What I would suggest is that storage is a good resource. It's equally as beneficial to the utility as it would be, for instance, to a solar developer. You take storage and you put it with one solar asset, and it functions that way at that point. We tend to think of storage as, or I do, as more of a utility-driven asset, because it can then create kind of what I would call wider public interest benefit. So if it was somewhere else, not next to solar, I think it could provide benefits to the utility. We use pumped hydro today to essentially address the overgeneration, but it's not an unlimited resource. So we have space, 576 megawatts of pumped hydro, but it's got a limitation. Utility could probably benefit from having additional storage as well as other investments in the system.
Okay, thank you, sir. That's all I have.
Ms.
Vice Chair Belzer.
Thank you, Mr. Chairman. Good morning, Mr. Cassis. How are you today?
Good morning, Commissioner.
Mr. Cassis, I was kind of in that same area that Commissioner Powers was just discussing with you. And a couple of places on page 6, you've referenced more advanced systems. And in one place you said more advanced systems like Dominion's. Tell me what you mean when you say advanced systems.
Yeah, no, that's a great question. So when I think of advanced systems, I think of less of direct procured solar, but a combination of storage, can be standalone storage, or it can be solar that operates more flexibly so that it doesn't provide the full outputs during the same periods that the rest of the solar profile operates, so that it's essentially back down, but then it can provide service at a different time than coincidental with those other solar assets. Today, they just pile on top of each other and they create a profile that our operating folks really have a challenge managing.
So what makes Dominion system an advanced system? Is it the pumped hydro that you just talked about?
We have the benefit of the 576 megawatts of pumped hydro. Other systems around the country have some of that. We just happen, on a system that generally, as I said, peaks at 4,700. It's a very valuable resource to it. It has allowed us to integrate the amount of solar up to this point.
Are there any other advancements, I kind of do air quotes with that allow Dominion in South Carolina to store that energy, that electricity to use later? Or are you, when you say advanced system, you're solely relying on the pumped hydro?
Yeah, that's the existing, Commissioner, that's the existing asset. I think the future vision could be utility-owned chemical storage. So it could be lithium ion. That could be a utility resource, which would then mitigate some of the risks. Most people think of it as coupled or paired with PV. I think of it as multiple ways to do it. It's one of the things that we should probably talk about with stakeholders is a better way, I think, to create more what I would call system flexibility.
One of the the charge in the statute and what was in the commission order referenced within the utilities balancing area. Can you explain what that is, please?
Sure. So the balancing area, yes, ma'am. Yep. Commissioner, so the balancing area would be our service territory. And although it is interconnected with other utilities, there's a limitation to oversupply that doesn't allow us to indiscriminately deliver energy outside of our service territory. So I'm not a balancing authority expert, but what as a system operator, I understand that you operate essentially with the responsibility to serve your load and not to overgenerate, and of course not to undergenerate. And so that's defined as the utilities balancing area. It's the load, and then your responsibility to create the reliable service from the supply.
Is there any how do neighboring utilities or do neighboring utilities impact that balancing area?
So there's a relationship between the utilities. So we share in simple things like sum reserve. And again, there are requirements that the system essentially create or be balanced, and it's in very short time periods. So there can be occasions when you're out of balance, but typically the utilities are working together in our region to address oversupply. But if everybody's, for instance, develops intermittent resources or resources that push energy to the other, the system essentially becomes unbalanced. You've got a protocol that you've got to follow within short time periods where you strike to balance the system primarily for reliability and ensuring that supply doesn't ultimately have to come offline in a way that's uneconomic or unreliable.
Mr. Cassis, thank you for answering my questions. Thank you. Mr. Chairman, that's all.
Thank you, Commissioner.
Thank you, Vice Chair Belzer. Any other questions for this witness from commissioners?
Chairman Williams, this is Commissioner Williams.
Commissioner Williams, you have the floor, ma'am.
Thank you. Mr. Cassis, thank you for being here. Good to see you again. I guess it's only been 2 weeks.
I feel like it was just yesterday.
We do too. I want to ask you about Act 62 and whether you had a role in helping to form it and create it.
Yeah, so I was one of the company's material matter experts. So as our legislative team worked on inputs to the legislation, I was part of the team. And quite frankly, it was primarily because of my experience in integrating the amount of renewables that we had done. I've also got experience as a system operator from an earlier part of my career. So we did provide input.
Okay. So the reason I'm asking is, of all of the elements in Act 62, this probably got the least amount of words, lines, definition. What, from your perspective, was the intention from the legislature's perspective with Act 62 regarding competitive procurement for renewable energy?
I would use I'll say this. I was in a prior proceeding, someone described Act 62 as a suite of things.
Right.
I wish the suite of things were more connected in terms of comprehensive. I thought Act 236, for instance, was much more comprehensive. I think there are certainly a number of good things. The legislature did a number of good things in Act 62. It probably wasn't maybe as comprehensive, but also I say this concept of competitive procurement is one of a suite of things to advance South Carolina in terms of approach to renewables. I would also say that part of our input was that in that process we wanted people to recognize that we've already had 20% 5-year system average peak renewables already essentially under contract when a lot of this was written. So the relative timing wasn't on some of these items weren't necessarily aligned with, I think, where we were in our balancing authority.
Well, more specifically then, do you think the legislature's intent with CPRE was to create guidelines to come back to the legislature with rulemaking provisions? I'm looking for a little bit more detail there.
Yeah, I think it was designed, or this is what I believe. I think I believe it's a tool. If that tool could then fit into the plan of the utility, specifically in that balancing authority, it provided the commission, I think, the flexibility. But I would put the framework around one, reliable. Can what we say we're going to do be done reliably? Can it can it provide other benefits, customer benefits? And then, will third parties be able to execute on what they say they're going to do? So, I think public interest is it's two words, but but it means a lot to a lot of different people. But I frame it up I have to frame it up as the system operator. I frame it up in a way that makes me want to ensure that we are first and foremost, providing reliable service. So, and if that means we're the ultimate backstop, I don't want the public interest impaired because what we're procuring doesn't work with what we're trying to do with respect to the level of service that we're required to provide.
Okay. But in terms of rulemaking or kind of coming back to the General Assembly with suggestions for new statutes, any specificity there? In terms of what you recall?
No, I saw it as I spent a lot more time in other places in in editing. For instance, I was a big, I might have been the only person in the room advocating for, say, for instance, interconnection reform. Right. I thought that was really important. And it's last on the list, and it was the thing that probably we should have done first instead of, my opinion counts less, Commissioner, I think, is what I'd say.
Okay, well, thank you. I appreciate that. You talked about in your testimony and just now about the relationship between competitive procurement and coming out of a planning process. Could you give more detail, especially having just done basically 2 IRPs? Paint us more of a picture of how competitive procurement could evolve out of and relate very strongly to an IRP.
Yeah. So, Commissioner, I'm not, directly involved. I don't write the IRP, but I provide input as to, how resources would work and how they would integrate. I think, you have an IRP and you're working to provide, I think, the most reasonable and prudent plan. It is a plan, but it is a roadmap. And that then becomes informational as to what products might be able to perform some, have some attributes that then might give you some value. And I put it in the context of reliability. So it's got to be adequate in terms of what it does. And that definition needs to be clear in that competitive process of what you're looking for. And then there's a financial consideration. In other words, if it costs way more than what someone currently deems as the best option, then I don't know that we can appropriately deem it in public interest if it's higher cost. I think those are the things that you're trying to weigh, and I think I agree you're thinking about it correctly. It's the linkage between specific needs in a plan and then how you could utilize competitive procurement to address some of those needs if they exist in that approved plan and you identify them.
Witness Cassis, thank you very much. Appreciate it.
Thank you, Commissioner.
Chairman Williams, no more questions.
Thank you, Commissioner Williams. Commissioner Caston?
Thank you. Can you hear me okay?
Yes, sir. We hear you loud and clear. Please proceed.
Good. Good afternoon, Mr. Cassis. I hope you can hear me okay.
Commissioner, you're fine. Yes.
Good. I'm probably plowing some of the same ground that's been plowed. and to be honest, it's not really real clear to me whether DESC kind of supports the CPRE idea, or that's still a little unclear to me. But that said, am I understanding you to say that you're not against the renewables in concept or solar in general, but am I understanding that you're saying that more direct solar may not be in the best interest of the utility and the customers? Is that correct?
Yeah, Commissioner, so I guess I'll take 2 points to respond. So first of all, I think I'm the signature on 1,000 megawatts of solar, a gigawatt of solar in South Carolina. So I'm definitely not against renewables. So and I think in order to achieve the level of decarbonization that our company's committed to, renewables are got to be a piece of that equation. The products that we've secured through those contracts are a certain type of product. They just you must deliver solar. And it truly is an integrated analysis to figure out what's the next increment of clean energy and how should that be appropriately integrated into your energy delivery system. So scale is good. I think it gets you to a price point gets you to competitiveness and even potentially least cost resource. But you can't operate it exactly the same way. That I guess the analogy that I would make, if you had a water system and everybody could deliver water from a tower anytime they wanted to, and they were guaranteed a certain price, then the pipes would essentially not be able to deliver what you're trying to deliver. But if there were more integrated ways to contract and use some of it sometime and then have other storage devices on that system, that's the analogy that I would make. It's got to be it's a much more complex analysis.
I think I heard you say something along these lines that I guess with the solar in particular, it tends to stack up pretty much during similar time periods, and there's nowhere for that to go. You don't have some storage bucket you can dump it in or way to store it, so the infrastructure itself can be iffy possibly, or your demands are such that you just don't need all that then. Is that what you're saying?
No, that's correct. The production generally peaks at the same time. So at 2:00 in the afternoon, we've got the greatest amount of solar. Our load on our system during the summer likely peaks now at 5 or 6. So it's less available to us then, but you can't keep stacking that same resource. By the same token, at 6 a.m. in a winter morning, we get nothing. We don't get any production from it.
All right, and you pretty much, I think, answered this with Vice Chair Belser's questions, but I've heard storage. I've heard you mention hydro, and unless you guys are building some more dams or developing more hydro, which I'm not aware of, it sounds like is the only option. Are there other options? Are there other hydro options? Are there other renewable options? You mentioned storage, but outside of that?
Yeah, so chemical storage is, which is, just lithium ion is what I would describe as the current technology. I don't know in a decade if that will be the technology, but we do have, for instance, no solar developer comes to me today and doesn't at least say, I want to do a hybrid installation where I've got some storage. And then I have other entities that are experts in standalone storage. So those are ongoing conversations. I don't think I'd be I would not be fulfilling my fiduciary responsibility to the company if I didn't engage with those parties on the products that they're offering. I would tell you that chemical storage has gotten more and more competitive. And those are conversations that are continuing to progress. The hydro is just a much more complex environmental entity where you've got all this governance about water flows, and so you're limited on what you can do. And you're right, it would be a massive undertaking. I think of storage as more about non-wire grid alternative. Might be really good for a utility, a way for them to invest to help, as opposed to not necessarily being coupled right with PV, right with solar, but places on the system that could help.
Okay, thank you. Does DESC support, I guess, South Carolina having its own version of CPRE?
I think done in the right way, that as long as it's solving a need, I believe our experts or their testimony, they've worked in other jurisdictions. They've seen how it can be deployed successfully. I think our testimony speaks for itself. We think it, as long as you're addressing a need, then I think it does, move towards addressing or fulfilling the public interest mandate.
Is there anything that prevents DESC from having their own version of CPRE?
No, I mean, I think in the end of the, that's really what we're saying. We think it should be our version. We're not averse to, and you would want someone for transparency to oversee it. We would want it to be, again, to be specifically addressed to needs. So if needs weren't coming up until later in, say, a planning cycle, there would be some time to make sure that whatever you did in the CPRE process, it aligned with or was closer to the iteration of technology. So for instance, if battery storage if you had a need, and say a need was in 27 or 28, it was in 5 or 6 years, you wouldn't necessarily want to spend a lot of time on CPRE when it was a common knowledge that battery prices would continue to decline at a rapid rate. You'd want to do it closer. You want to participate in that process or stage it closer to when the need was going to take place.
Understand. I know IRP has been mentioned a time or two, and there was some hesitation on your part, and I understand that. But if the utility did have a well-developed IRP, would this not direct, in essence, the utilities' own CPRE? Would it or could it?
Yeah, it could. And look, Commissioner, I hope we've done what the commission expects with respect to the IRP, with the modified filing. So I believe, and I think it's a good plan as filed now. But yeah, there is definitely a relationship with the IRP demonstrating those needs. And then if those needs are truly recognized, then that could be a CPRE process could be something that could be utilized in that plan.
Again, I believe, I recall some of DESC's witnesses specifically addressed the IRP as fairly instrumental in this process. And I think Witness Brown also addressed it both ways, and it seems like it certainly can be very appropriate, but there can also be concern relative to looking out into the future, and if you assume wrong on what cost may be, then just using an IRP to guide it is not the correct way, or the be all in all way to do it, I guess. That said, still trying to gather information. I appreciate the information you've shared, and I look forward to hearing the other witnesses. Thank you very much. Thank you, Chair Williams.
Thank you.
Thank you, Commissioner Caston. Any more questions for this witness? Hearing none, any redirect?
Thank you, Mr. Chairman. This is Ashley Cooper for Dominion. I do have some redirect.
Please proceed, sir.
Thank you, Mr. Chairman. Mr. Cassis, you were asked several questions about Dominion's IRP process. Does Dominion's IRP process that you've testified about, does it call for any generation resources before 2026?
The first time I think that the modified, plan calls for generation resource, it's 2026, I believe, and 2027.
Yep. Thank you, Mr. Cassis. So to be clear, you don't have a need in 2021.
That's correct. The first, and this still requires actually study, but if the plan that was proposed advances, it wouldn't actually require a resource until 26.
Okay, that's correct. Thank you. So you had some questions that asked you about your statement that any sort of CRP should be tied to a need. Does Dominion Energy South Carolina, particularly in the short term, does it have a need for a CPR? Would a need be adding more solar energy in the short term? Would that be a need to justify a CPRE now?
No, I don't think it would right now.
Okay, thank you. I want to now turn, you were asked some questions about storage. I just want to clarify. Battery storage can be a generation asset, correct?
That's correct.
And it can also be a distribution or a transmission asset. Is that correct?
That's correct.
So you could have storage paired with a solar PV. That's one model. Is that right?
That's correct. That's a hybrid installation.
But also Dominion Energy can deploy storage as a distribution or transmission asset that would allow it to help balance and maximize its system and promote efficiency for all sorts of generation.
That's correct. It would be similar to operation the way you would operate pump storage hydro. You could just place them all throughout the system.
Okay. So is it your testimony that if Dominion added storage, it could have a broader impact in terms of the benefits to the system?
That's correct.
Okay. And Mr. Cassis, I now want to, do you have your testimony in front of you?
I do.
Could you please turn to page 6?
Okay.
I just want to clarify, you were asked a question, and if you look at line 12, you were asked a question about what you meant by an advanced system. So I'd like for you to read your testimony on lines 12 and 13, where it says more advanced systems like DESCs that have adopted a significant level of renewable generation. So did you intend advanced systems to mean a system like DSC that has a significant level of renewable generation?
I did.
Okay, so that's really is that what you meant by the term advanced?
Yeah, that's correct. It's just advanced in the, I guess what I would describe as the renewable continuum. It's just got more renewable resource than most balancing authorities, almost any balancing authority.
Okay. Thank you very much. And you testified about last Friday, conditions on the Dominion system last Friday, where it had to curtail solar generation, correct?
Yeah, that's correct.
Okay. And at that time, did Dominion have to curtail any non-solar generation that it owns?
That's correct. It curtailed, actually it curtailed very low cost system generation.
So just to be clear, you curtailed some of your own generation in addition to curtailing certain solar.
Yeah. So to the extent that you allow as much of that solar to stay, but you've got to balance the system as we described. And in order to do that, if you can take off some of that resource, even if it's the least cost resource or low cost resource, it comes off and to leave additional solar still on the system.
Thank you, Mr. Cassis. And I'm sorry, Mr. Cassis, I actually interrupted you. You said, you started to say before I interrupted you that we actually curtailed a lower cost Dominion asset. What was the cost of the Dominion asset that you curtailed?
It was a gas asset. So the price was $19 a megawatt hour.
And can you just approximate for us, Mr. Cassis, about how does that compare to the PERPA contracts, the solar generation that you had running at that time?
So the solar contracts were that vintage that was curtailed were likely the $38 contracts.
Okay.
$38 a megawatt hour.
Thank you, Mr. Cassis. And Mr. Cassis, I want to ask you about PERPA and understand it's maybe outside the scope of which you can address here on stand, but is it your understanding that PERPA only allows you to curtail without paying the generator for what it could have provided during an emergency situation? Is that right?
That's correct.
Okay, and then the only other way is if you happen to negotiate and there's a negotiation where both parties to a contract agree to provide some specific contract language that allows for curtailment without penalty.
That's correct.
Okay, so it's possible that when you curtail solar, it's possible. I'm not directing it to you. Let me restart my question. So under PERPA, a utility may curtail solar, but it may still pay the solar provider for what it was capable of producing. Is that a correct statement?
That's correct.
Okay, and Mr. Cassis, I just have one set of things I want to go through now. I want to switch gears, and you've had a lot of questions about the purpose of this docket and adopting guidelines and what Act 62 meant. So I just want to go through a couple of things with you along that line. So Act 62 says the commission is authorized to open a generic docket for the purpose of creating programs if the commission determines such actions to be in the public interest. Do you believe that this commission was required to open this generic docket?
I think it says they're authorized.
Right.
to
So,
open. I don't think it says it's required.
thank you. And then do you have, I think you answered some questions about the commission's directive, and if you don't have it handy, I can put the commission's directive in front of you on the screen, but do you have the commission's directive handy?
I do.
Okay. Do you see, I know you read off that you had prepared testimony along the lines of the 6 requirements in the order. But if you go up before that, do you see a paragraph right before where you start listing the best practices? Do you see a paragraph that says, I further move that the commission reaffirm?
I do.
Okay. And could you read that paragraph to just to the point where it says as follows? Could you read that paragraph for us?
I further move that the commission reaffirm its finding that it should explore a South Carolina competitive procurement program as allowed by South Carolina Code Section 58-4120E2 and proceed with this generic docket at this time as follows.
And so, Mr. Cassis, is it your testimony that you believed you were that this docket was to explore South Carolina competitive procurement programs?
That's correct.
So you view this as a generic docket to consider all the various aspects in forms in ways a CPRE can take shape?
Yeah, that's correct.
Okay. Now, you were asked about adopting guidelines, and these guidelines were an attachment to Mr. Levitus's testimony. In the directive that we just read from, it doesn't state anywhere that in this generic docket to explore, that we might adopt guidelines in this particular docket, does it?
It just says it should explore.
Okay, so no, you did not have notice that the commission would be considering adopting guidelines in this docket based on this directive.
I read the reason and then read the 6 specific things.
And before the commission can adopt something like these guidelines in an order, there has to be notice and an opportunity for all parties to be heard. Do you think that all parties have been heard on the issue of adopting guidelines?
I don't think so.
And isn't it true that you received, from the date you received Mr. Levitus's direct testimony, it's the same date you received Mr. Searcy's direct testimony, which is also the same date you received Mr. Brown's direct testimony. From that date to the date you had to file your responsive testimony, isn't it true you had 4 business days?
Yeah, I believe so. That was during Solar Choice. It all blended together for me.
Right. Okay. Thank you very much, Mr. Cassis. Mr. Chairman, thank you for this opportunity to conduct redirect. I have nothing further at this time.
Thank you, Mr. Cooper. Mr. Cassis, you may step down from the witness stand.
I'm sorry, Mr. Chairman. I apologize for interjecting. Would we have the opportunity to do any recross?
Briefly.
Okay. Thank you, Mr. Commissioner, or Mr. Chairman. And I'll try to be brief here. Mr. Cassis, Mr. Cooper asked you some questions about the company's IRP. Is that right?
He did.
Okay. And just to be clear, that IRP has not been approved by the commission, has it?
Yeah, it's just been filed, and then the commission obviously has to look at it as well as Office of Regulatory Staff.
Okay, understood. Mr. Cooper asked you some questions about the curtailment issue when solar is generating, at peak times. Do you recall those questions?
I do.
Okay. And I believe you mentioned that storage, additional storage is one way to address this, this oversupply issue, I guess, as you've characterized it. Is that right?
Storage utilized either by a solar developer or by the utility can be utilized and can certainly help with curtailment risk.
Okay, and you have talked about the benefits of standalone storage. Is that right?
I'm a believer in standalone storage.
Could the company do a procurement for standalone storage resources?
It could.
But I'm sorry, go ahead.
No, that's fine.
If the company were to do a procurement of standalone storage resources, though, those resources would not be able to take advantage of the investment tax credit, would they?
You would have to meet the, if you're saying, I think your question is to monetize the tax credit and to couple it with PV, that same option doesn't exist for standalone storage.
But standalone storage is not. I'm sorry, go ahead.
Right.
The standalone storage is not eligible for the ITC, but storage coupled with solar generation is eligible for the ITC, right?
Yeah, subject to meeting the conditions that the IRS requires when you create the hybrid arrangement.
So the company, if it were to do a procurement for solar plus storage, could potentially get storage more cheaply than it could if it were to procure storage on a standalone basis.
I would definitely not say that it could be done more cheaply. I think it would change the way the developer would finance. So their capital stack would be subject to tax credits. But I don't know whether I would say completely it would be cheaper.
Understood. Another way you talked about dealing with this curtailment issue is a flexible PPA. You recall that?
Yeah, correct.
Okay, and that's a power purchase agreement that provides payment on a capacity basis, right? Versus
Mr. Chairman, this is actually Cooper, counsel for Dominion. I did not ask on redirect any questions about a flexible PPA or flexible solar.
Sustain.
Okay. Mr. Cooper did ask you questions about curtailment of solar resources, didn't he?
He did. I think he asked me a specific question about issues we had on the system recently.
And you discussed the fact that with a default PURPA contract, curtailment, generally speaking, has got to be compensated. Is that right?
That's correct.
Okay. But the company could contract through a procurement for limited curtailment rights that would be uncompensated, couldn't it?
Yeah, they could. We could.
Okay. And that's a feature of the PPAs that Duke has contracted for under its existing CPRE program, right?
Yeah, Counselor, if any developer wanted to come to me with a provision, any of the 3 or 4 that are talking to me now, they could certainly do that.
Okay, but that could be a feature of a procurement, this like limited curtailment rights.
It could be a feature of a bilateral contract between the company and a solar developer. Correct.
Mm-hmm. But those limited curtailment rights would help address this curtailment issue. Is that right?
I think it would have to be studied. It's becoming more and more prevalent. I think the challenge is that the contracts that exist already have value in those contracts, so they're very specific. So I doubt developers are willing to give up some of the value in those contracts. So I think a new contract, yeah, they could be.
Thank you. And one, just a couple more questions, and I'll be finished up here. It's March 2021 right now. If you were to walk out of this hearing and Dominion were to start a procurement program just next week, they wouldn't be able to get projects operating by the end of 2021, would they?
No, only because I think there's matters such as witness Mans will talk about around interconnection.
Understood. Well, you've
So
got
there's a
I mean,
significant backlog. Yeah.
there are a lot of steps that have to take place before projects can start operating, right?
Yeah. Witness Mans could talk about what I think is probably the most challenging piece, which is likely, even though there's 4,000 megawatts of solar in the queue, it still operates as a serial queue. And although we're working with stakeholders, such as the South Carolina Solar Business Alliance, to change that, it's going to take some time because some projects certainly have positions in the queue where they're going to want development rights, and then others maybe behind those. I think that's a big issue.
Understood. But with all these issues, even if we were to start tomorrow, it could take a couple of years before any procured solar would begin generating. Is that right?
It would be hard for me to say. It would take time. It would definitely take time to reform queue and involve the stakeholders to address contractual issues. All those take time. And again, it should be with respect to the utilities balancing area.
Okay, thank you. Those are all the questions that I have.
All right, Mr. Witness, you may step down from the witness stand.
Thank you, Commissioner.
Ladies and gentlemen, it is 12:50. I think it's a good time for a lunch break. Let's come back at 1 o'clock. I'm sorry, 2 o'clock, 2 p.m., 1400. All right. We're in recess until 2 p.m.
Testing, check, 1, 2, 3. Competitive procurement of renewable energy docket number 2019-365E. Does that sound all right? Testing, 1, 2, 3. Check, 1, 2, 3. Testing, 1, 2, 3. Check, 1, 2, 3. Testing.
Good afternoon, ladies and gentlemen. Welcome back to the Public Service Commission of South Carolina's hearing in docket number 2019-365E. Let's take roll. In the hearing room, we have Commissioners Thomas and Powers, along with Vice Chair Belzer, and Chairman Williams. Joining us virtually, and we have some issues with our monitors up here, but joining us virtually, we have Commissioners Caston, Williams, and Irvin. Before we broke for lunch, we finished with Dominion's first witness. Dominion, please call your next witness.
Thank you, Mr. Chairman. At this time, Dominion Energy South Carolina calls Dean Kojak to the stand.
Mr. Kojak, if you could take the witness stand and please pause to be sworn in.
Yes, this is Dean Kojak.
Mr. Kojak, if you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much.
Thank you. Mr. Kojak, please state your name for the record.
Sure, Dean Kojak.
And by whom are you employed and in what capacity?
I'm employed by Guidehouse, Inc. as a director.
Have you prepared or caused to be prepared under your supervision direct testimony of 19 pages that was previously filed with the Commission on February 22nd, 2021 in this docket?
Yes.
And do you have any changes or additions to your pre-filed direct testimony?
No.
If I asked you the same questions here today, would your answers be the same?
Yes.
Mr. Chairman, at this time, I move that the pre-filed direct testimony of Mr. Kojak be admitted into the record as if given orally from the stand.
The pre-filed direct testimony of Mr. Kojak will be entered into the record as if given orally from the stand.
Thank you. Mr. Kojak, have you prepared a summary of your direct testimony?
Yes, I have.
Would you please deliver it at this time?
Okay, thank you. Good morning, Chairman Williams and members of the Commission. My name is Dean Kojak. I provided direct testimony in this docket on behalf of Dominion Energy South Carolina, Inc. on February 22nd, 2021. I respectfully request to provide the Commission with this summary of the same. I'm employed by Guidehouse, Inc. as a director. I have over 17 years of experience in the electric power sector, and I've worked with utilities as a power procurement advisor, administrator, and an independent monitor in the U.S. and Canada. The purpose of my direct testimony is to address specific items identified by the Commission in this docket, including best practices, challenges, and costs, and the various forms of CPRE. At a high level, CPRE is a structured competitive procurement process that's designed to provide renewable energy to the procuring utility under long-term contracts. CPREs have typically allowed for a specific quantity of renewable energy to be purchased at competitive prices, which could even be lower than the utility's avoided cost. As I'll discuss further, CPREs can take numerous forms. In my experience, two of the most common types of CPRE programs are all source and single source. An all source RFP permits various types of renewable resources to bid, while a single source RFP only permits one type of renewable resource to submit bids. The bidding process can vary under each of these options as well. Although a CPRE should choose winning bids on price alone, shouldn't select bids on price alone. Non-price factors such as reliability and operating experience should be considered as well to ensure system reliability and cost effectiveness. CPREs have been implemented in a variety of ways and can provide a complementary procurement strategy to a utility's purchases under PURPA. PURPA requires a utility to purchase renewable energy from qualifying facilities at avoided cost rates, but it does not ensure that the power meets the needs of the utility, such as quantity or optimal location. On the other hand, CPREs can be structured in a way that permits the utility to consider both the price and non-price factors to provide a greater customer benefit while also providing greater revenue assurance for project owners. Even though CPREs can take various forms, my experience indicates that there are certain best practices in implementing CPREs. For example, the procurement of renewable energy, just like any resource, should be cost effective and tailored to system needs, which highlights the need to coordinate a CPRE with the integrated resource planning process. A CPRE can be designed to procure specific needs identified in the IRP, which is especially appropriate on a system with substantial renewable resources already in operation. To ensure these processes are coordinated, the timing of the CPRE should be aligned with an adopted IRP. Another best practice is to permit third-party projects and utility-owned projects to participate in the CPRE process. Permitting the utility to bid provides certain benefits to ratepayers. For example, there are certain projects that can only be advanced by a utility given the impracticalities related to transferring certain utility-owned real estate and interconnection rights. Given the various concerns and options inherent in the CPRE process, a stakeholder process prior to implementing a CPRE can also be beneficial, particularly to customers. This stakeholder process can proactively address problems that could arise from the CPRE and increase the overall transparency of the process. To bring additional transparency to the process, utilities could adopt general guidelines for RFPs, such as separation protocols for utility personnel that ensure a fair evaluation of each bid and promotes a level playing field. In furtherance of a fair and transparent process, a CPRE should contain an element of independent oversight. This oversight typically comes in one of two forms, an independent administrator or an independent monitor. The administrator model typically manages and executes the entire process, while the monitor model provides oversight to the utilities management and execution of the CPRE. In each scenario, the goal is to ensure fairness and consistency. I have personally served as both an independent administrator and an independent monitor. And in my experience, the independent monitor is a better and more cost-effective approach. The independent administrator is typically not as well equipped to conduct an in-depth qualitative and quantitative analysis required to ensure that the projects provide benefits to ratepayers rather than increasing the costs to ratepayers. This type of cost-benefit analysis must include all costs, such as integration costs and energy price, and all benefits as well, such as the reduction in the utility dispatch costs and the capacity value. As you can see, there are a number of complexities to consider when implementing a CPRE. These complexities necessarily require a substantial commitment of time and money. Although a successful CPRE could result in monetary savings, there must first be an identified need in the IRP. Even then, these monetary savings must be assessed against the opportunity that may have been lost to put in place other potential resources that would maximize savings opportunities. In summary, implementing a CPRE program involves complex issues that can vary from utility to utility, but these best practices should be considered and evaluated during any such process. I thank the Commission for its time, and this concludes the summary of my direct testimony.
Thank you, Mr. Kojak. Have you also prepared or caused to be prepared under your supervision responsive testimony of 10 pages that was previously filed with the Commission on March 1st, 2021 in this docket?
Yes, I have.
And do you have any changes or additions to your pre-filed responsive testimony?
No, I do not.
And if I asked you the same questions here today, would your answers be the same?
Yes.
Mr. Chairman, at this time, I move that the pre-filed responsive testimony of Mr. Kojak be admitted into the record as if given orally from the stand.
The pre-filed responsive testimony of Mr. Kojak will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Kojak, have you prepared a summary of your responsive testimony?
Yes, I have.
Okay, would you please deliver it at this time?
Sure. In my responsive testimony, I highlighted certain common ground between DESC and witness Cersei and respond to several points made by witness Levitas that are outside the scope of this docket as outlined by the Commission. With respect to witness Cersei, I agree with the statement that a CPRE should be flexible enough to address the unique needs of the jurisdiction as identified in the IRP. This ensures that the CPRE process contributes to the reliability of the grid in an economical way. Witness Cersei correctly notes that the IRP should be well developed and drive the CPRE process because a CPRE process that is not aligned with the IRP could result in additional costs to ratepayers. In furtherance of protecting the ratepayers, witness Cersei rightly recommends that the comprehensive evaluation criteria, comprehensive evaluation criteria and guidelines be implemented to guard against realization risk or the risk that certain projects will not achieve commercial operation. However, conducting a near-term CPRE, as witness Cersei recommends, to obtain institutional knowledge is not necessary in my view and could result in premature costs to ratepayers and is not tied to any need in the IRP for such a process. With respect to witness Levitas, several of his recommendations, including the ones I'm about to mention, fall outside the parameters set for this docket by the Commission and, in my view, does not comport with the established best practices based on my experience. For example, witness Levitas notes that utilities and their affiliates should only be allowed to participate in CPRE if cost recovery is done on a market basis. But my experience indicates that this is not a best practice and ignores the key advantages that pass on to ratepayers by incentivizing utility participation, such as cost-effective energy integration. Witness Levitas goes on to state that even where utilities and their affiliates participate in a CPRE, caps should be placed on the awards they are eligible to receive. In my experience, this is also not a best practice and could result in suboptimal outcomes. Consideration of any such cap is premature at this stage, given that we do not know any of the details about the proposed CPRE. I also disagree with witness Levitas' assertion that the independent administrator should be the preferred model of independent oversight for all the reasons I cited in my direct testimony, which includes the increased costs and lack of expertise under the administrator model. Witness Levitas' suggestion that the non-negotiable form contracts should be used for all CPREs ignores the benefits arising from flexibility within the CPRE process to address project and jurisdiction specific characteristics. In my experience, developers typically expect to negotiate certain contractual provisions. Accordingly, prescribing a form contract could bar competition. Although non-price terms in those contracts can affect pricing, it's not advisable to create a form contract in a generic docket that would be utilized for all CPREs, regardless of the contours of each specific CPRE. Even where a form contract is developed in the context of a specific CPRE, bidders should still be allowed to propose multiple options and revisions to certain terms of the proposed contract that could benefit the utility and its customers. In my experience, this is the best way to ensure a level playing field when it comes to these contracts because it permits all bidders to propose contract exceptions as they see fit. Finally, in response to witness Levitas' recommendation to consider an all-source CPRE, I agree with this recommendation in part. An all-source RFP allows for a multitude of technologies to compete in order to address the specific needs, attributes, and characteristics of the generation procured as identified in the IRP. Embedded in the design of a CPRE should be the needs, attributes, and characteristics of a resource identified under an IRP. Otherwise, the CPRE would have the net effect of compromising reliability, which is an unacceptable outcome for the utility customers and regulators. I thank the Commission for its time, and this concludes the summary of my responsive testimony.
Thank you, Mr. Kojak. Mr. Chairman, Mr. Kojak is available for cross-examination by the other parties and questioning by this commission.
Duke Companies.
No questions for this witness, Mr. Chairman.
Carolina Clean Energy Business Association.
Yes, Mr. Chairman, we have some questions for this witness.
Please proceed.
Good afternoon, Mr. Kojak. Thanks for being here.
Thank you. Good afternoon.
So, Mr. Kojak, you testify in your direct testimony that, and I believe you just said in your summary, that CPREs should be driven by resource needs and plans identified in the utility IRP process. Is that right?
Yeah, that's correct.
And you've reviewed Mr. Levitas' direct testimony, as you said, correct?
That's correct.
Mr. Levitas testifies, and I'm looking at his direct testimony on page 30, line 13. Mr. Levitas testifies that the Commission should direct each South Carolina investor-owned utility to conduct a competitive solicitation for any new renewable energy resources identified as needed within the next 5 years in the preferred resource plan approved by the Commission in the utility's current IRP proceeding. Is that right?
Can you give me the reference? Sorry,
Sure,
page 30?
Page 30, starting on line 13.
Okay, I see that, yes.
Okay. So essentially, Mr. Levitas is saying that, competitive procurement should be driven by the resource needs identified in the IRP. Is that right?
Yeah, according to a read of this, yes, he is saying that as well.
Okay, so that's a point that you two agree on. Is that right?
Yeah, I would agree insofar that the IRP should drive the timing and the need. Yes.
Okay. So Mr. Levitas is not advocating for the Commission to direct a procurement that's not driven by the IRP, is he?
I think there's other areas of the testimony that may suggest a nearer term solicitation. I have no basis to. I'm unsure what your question is. Can you restate?
Sure. Mr. Levitas is not advocating that the Commission direct a procurement that is not driven by the resource needs identified in the IRP, is he?
I can't speak for him. I've reviewed his testimony. I made specific observations in my responsive testimony with respect to his testimony.
Okay, so you don't recall him making such a recommendation in his testimony?
Not off the top of my head, but I believe there are some certain points raised that I identified in my responsive testimony that suggest that a potentially a more nearer term CPRE would be advisable.
Okay. Are you thinking about Mr. Searcy's testimony, perhaps?
Perhaps, yeah. That may be correct. Apologize for that.
Thank you. All right. And did you hear Mr. Cass's testimony from earlier about the level of solar penetration on Dominion's system right now?
Yes, I have.
Okay, and he questioned how much value more solar would add to the system. Is that right? Do you recall that?
I do recall that, yes.
Now, that's the sort of question that the IRP would answer, isn't it?
Yeah, that's correct. Yeah, absolutely.
Okay. So if the IRP were to say, a procurement of renewables or solar has got, value or is in the preferred resource plan, that pretty much answers the question of whether it's economical for the ratepayer.
Yes, in accordance with the number of factors, including the timing, the timing in which reflects, load growth and many other factors that are considered in the IRP to align it with the specific needs.
Okay, understood. Thank you. So, Mr. Kojak, in your direct and rebuttal testimony, you discussed the participation of utilities and their affiliates in competitive procurement programs, right?
Yes, that's correct.
And Mr. Levitas, in his testimony, as you said, advocates a 30% cap on awards made to utilities and their affiliates in a procurement. Is that right?
Yes.
Okay. And that's the cap that the North Carolina General Assembly established for the North Carolina CPRE program, isn't it?
I'm not as familiar with North Carolina, but I'm commenting on the application of the cap more generally, and not specific to a specific jurisdiction.
Understood. But you testify in your rebuttal testimony that utility and affiliate participation enhances competition and benefits customers, doesn't it?
Yes.
Okay, and it's your view that placing caps on any participant limits competition and can result in suboptimal outcomes for customers?
That's correct.
Okay, and then you say you do not recommend any caps being placed on the utility or its affiliates?
That's correct.
Okay. So to be clear, it's your position that there should be no limits whatsoever on the utility's participation in its own procurement?
Yeah, I don't believe in the imposition of limits on any party with respect to competitive procurement. Competitive procurement requires wide and broad participation without, and you know, we've seen certain developers in different jurisdictions able to drive a more competitive result, and so they may have a higher market share. Same thing goes for inclusion of a utility. If there's an opportunity for them to deliver or propose projects that are cost effective, there shouldn't be any limitation on that.
Understood. And you do say also that unlimited utility participation is especially important where there are few market participants?
Yes, yeah, and this comes from my personal my experience with other utilities, in other jurisdictions. Where there's few market participants, they may exercise market power and drive the cost, may not be as competitive as it would be absent utility participation.
Understood. So would you anticipate there being few market participants in an RFP for renewable energy in South Carolina?
I do know a number of developers are involved in this proceeding. I can't say for sure. It always depends on the specific contour, the design of a procurement, and how many projects are already in the pipeline or could be potentially developed in the timeline afforded under a CPRE. The more time you give developers, the better. If there is a further out need date, that gives the notice to the market so that they can start developing their projects well in advance. And that drives competition.
Mm-hmm. Did you hear Mr. Cassis testify earlier today that there was something like 4,000 megawatts of projects in Dominion's interconnection queue?
I don't recall that specific point, but I do note there was a significant amount of solar in the interconnection queue. Yes.
Understood. And you would anticipate, wouldn't you, that some of those projects that are currently in the interconnection queue would seek to participate in a procurement program, wouldn't they?
Yes, the interconnection queue is an indicator of potential how competitive a procurement would be. That's one area you'd look at.
So, given that, wouldn't you anticipate that a procurement program would be fairly competitive as it stands?
It depends. It depends on the eligibility criteria in the CPRE. As I've applied similar rules in the past, a lot of times some of the criteria would require a project to be in a more mature state. The projects in the interconnection queue, without looking at how mature they are, how well developed, whether they meet certain threshold criteria, I've seen interconnection queues really boil down fairly quickly when you kind of review it, particularly if the depending on what the bar is to submit an application.
Understood. So, Mr. Kojak, you'd agree that where a utility does participate in an RFP or its affiliates do, it's important that there be a level playing field for all participants, including the utility?
Yes.
Yeah. Okay. And you've read Mr. Levitis's recommendation that if a utility participates in a CPRE, its cost recovery for any utility-owned projects that are selected should be on a market basis. You read that?
Yeah, I've read that.
Okay, and he also recommends that the utility should not be able to rate base those assets after their contract is completed. Is that right?
Yes, I've read that. Yes.
Okay. And do you understand Mr. Levitis to say that rate basing of those projects would create a non-level playing field between the utility and non-utility participants?
So I disagree with that point. So when I look at level playing field, I look at everybody having the opportunity to bid in. When a utility rate bases an asset, the arrangement is essentially the same as a PPA, where there is a low amount of curtailment or curtailment rights, which is kind of on par with PURPA at the moment. So they are recovering a fixed amount, which is based, and if you look at a PPA, it's on an annual basis, particularly for solar resources. The median production is quite consistent. So in essence, it is the same. It doesn't really materially differ. But the market basis, it's impractical. The mechanics of a utility executing a PPA with itself is impractical. It also overlooks the potential benefits of the utility can bring to customers, to ratepayers, when it does rate base the asset. Its recovery is capped in accordance with the rate case. It also typically, if it delivers the project at a cost less than the original estimated project cap, whatever the project cap is set at, which is typically the bid price. If it delivers it at a cost lower than that, that benefit typically goes to the ratepayers, which is a benefit that's not realized on the PPA side. So if we were to kind of look across the board, you look at kind of the benefits, net risk, on a risk-adjusted basis, it's effectively the same, in my view.
Well, let's unpack that a little bit. You talk about the potential benefits to ratepayers of a utility rate-based project coming in under budget, right?
That's one area.
Okay, and by the same token, if that utility-built project came in over budget, there's a risk that ratepayers would be harmed by that, isn't there?
So what I've seen in jurisdictions, they've adopted an approach where the cost is capped. So the utility has to bid a price with a certain level of contingency that it agrees to maintain. And the cost, if they were to exceed that, would not be borne by ratepayers.
Okay, understood. Going back to the certainty, because you talked about the certainty of revenues for rate basing versus a PPA on the other hand. Isn't the term or the duration of utility cost recovery on an asset different than, say, might that be different than the term of a PPA that is offered under a procurement? So you might have a 20-year PPA offered, but a 35-year rate recovery for the utility, couldn't you?
Yeah, with respect to utility-owned assets, the utility owns it for the entire duration of its life, so it would go beyond just the PPA term. It would have the terminal value as well as the first 20 years of operations.
Okay, understood. So a third party, an independent participant, might have revenue certainty for 20 years, but then have no idea what their revenues are going to be after that, right?
That's right. Actually, it's the same issue occurs with utilities. It's hard to predict the market 20 years out. It depends on the financing. It may be fully depreciated by the 20 or 25-year mark, depends on the cost of the recovery treatment.
But if the utility has, gets cost recovery, it might have revenue certainty for like a 35-year period, wouldn't it?
Yeah, I mean, after a certain period of time, after the asset is fully depreciated, it's only a matter of ongoing, you know, O&M, a certain upkeep, which is at a substantially lower cost to maintain the benefits of the energy. So the cost structure, there's a certain benefit, you know, in that model, and depending on how you evaluate it, you know, that's something that either is considered in the context of a procurement evaluation process or taken out. You could look at the first 20 years only, or 20 to 25 years, the PPA term, as a means to normalize the evaluation.
Okay, well, let me ask it another way. If a utility has got certainty over revenues from a project for a longer period of time than a third-party participant, doesn't that give the utility a competitive advantage when it's bidding into a procurement program?
The PPAs are typically of a long-term nature. That's typically aligned with the tenor of the debt instrument that backs the project. In terms of the utility cost recovery treatment, it depends on, you know, that goes into the financial mechanics. You could align it potentially to be effectively the same with all the added benefits or delivering additional terminal value of the project to the ratepayers that otherwise wouldn't occur under a PPA structure. You know, in my view, these are all options that should be considered and effectively evaluated in the context of a procurement. A lens I typically adopt in procurement is, you know, what is in the interests of ratepayers? How do we minimize costs and maximize benefits? Preserving all these options is a part of that. You know, and the methodology of the evaluation, whether it's, you know, through rate recovery or through a PPA, these mechanics would be fully fleshed out as part of the guidelines that the utility would develop in response to a CPRE type program.
So would you agree that whatever guidelines get approved by the commission should ensure that there are not structural advantages for utilities participating in the RFP as compared to third-party participants?
I believe those structural advantages should be, if any, should be explored. But, you know, when a decision is made, it should be more from the lens of what is in the best interest of customers and ratepayers. That should allow the certain benefits these utilities bring be effectively compared against the certain benefits that developers could bring to the table. You know, there's a balanced approach. You know, you look at both options and you render a decision accordingly in the context of procurement. You know, the PPA approach cuts off any further benefits after 20 years. It's typically fully, the cost has been fully amortized at that point, and you would enter into either further negotiations for a PPA renewal at that point at a market-based rate. So that could drive increased costs. So that's one factor to consider when you're evaluating utility versus PPA ownership.
So in your view, it's okay if the playing field is slanted just a little bit if that's in the interest of ratepayers?
You know, I think if you look at the balance of risks and benefits, the utility is only recovering in accordance with the rate case, and the term could be aligned. So these are decisions or issues that would need to be further evaluated, you know, as part of any program development. I think there's ways I have normalized the two approaches to align the utilities recovery or essentially shorten their issuance of debt or other financial mechanics to recover the project's costs within the 20-year horizon, so such that it's on the level playing field with a PPA approach.
Okay, thank you. So going back to your direct testimony, you do testify that an appropriate level of oversight is important to ensuring that there is a level playing field in procurement. Is that right?
Yeah, that's correct.
Okay. And why is oversight necessary when the utility is able to participate in an RFP?
In those cases, there's a perception, the utility is evaluating its own project, essentially. The oversight function ensures that there is a separation between the evaluation team within the utility, and if there is a self-build team that is developing a project that's responding to that same RFP, that they are removed from the process and would have the same access as developers do to utility information. In this role, I monitor all communications. Typically, I ensure that everybody's receiving fair treatment. I also review the evaluation process, the quantitative and qualitative evaluation for consistency, and try to align it. We try to align it as much as possible. There are certain criteria that do not apply to a utility, because it's not, for example, for contract exceptions, that would not apply, for example. But we'd look at the potential risk under the alternative scenario, which is the cost recovery approach. And so that's how it would be normalized.
Mm-hmm. Well, I appreciate you telling me a little bit about how oversight works. But my question is, why is oversight necessary?
I believe I answered that question. That's it's to ensure the process has integrity. The utility is involved in the evaluation, and there is also a potential utility self-build team that would be developing a proposal. So those two teams need to be separated, and the evaluation team in the oversight process would ensure that the bids are all evaluated in accordance to the established process plan.
So in your testimony, you mentioned this, you discussed the use of an independent administrator to provide oversight versus an independent monitor. Is that right?
Yeah, that's correct.
Okay. And can you just, I think you've explained in your testimony the difference between an IA and IM, but as I understand it, an IA, an independent administrator, will actually come up with the evaluation and selection criteria and run the process. Is that a fair characterization?
Yes, that's typically what's done under an IA approach.
Okay, and an IM where there's an IM, the utility will do all those things, but the IM will be looking over its shoulder to make sure everything is run fairly. Is that fair?
That's correct. There's a lot more, when I'm involved as an IM, I typically, a lot of the work is upfront in the actual development of the evaluation process. That's what sets the tenor for the entire RFP. So it's reviewing the qualitative and quantitative evaluation process generally, timeline. We look at the RFP design. Every element of the procurement is evaluated under the IM approach.
Thank you. And you testified that the use of an IA is just not practical in most RFPs, except for narrowly defined solicitations with clear established mechanical rules for qualifying and selecting bids. Is that right?
Yes.
Yeah. Okay. So is it your testimony that if Dominion were to procure renewable energy to meet the needs identified in the IRP, it wouldn't be practical to use an IA?
So you could use an IA. To me, it's suboptimal. If you're trying to optimize resources and you want to evaluate the contribution of those resources to the system, leveraging some of the utility staff, particularly the modeling folks, the folks who understand the system and are able to determine how a specific resource would operate over the specific time horizon. Those are the kinds of benefits or capabilities you would have under a utility-led process as opposed to an IA-led process.
Okay, so the key advantages to the IM approach are you get to leverage the utilities resources when you evaluate projects. Is that fair?
That's correct, and particularly the particular service territory, understanding the topography, the benefits of locating resources in specific at specific points on the interconnection system. Also, there's other aspects of the qualitative evaluation which are important, and depending on the IA, they may or may not have that same level of insight as certain utility personnel would.
Thank you. Are you familiar with the CPRE program that's run by Duke Energy in North Carolina and South Carolina?
I have a high level understanding of that process. I have not yet kind of delved into great detail into that, but I have an understanding of that, higher level understanding.
And you're aware, though, that Duke uses an independent administrator in the CPRE program, is that right? Or are you aware of that?
I am aware of that, yes.
Okay, do you know how the independent administrator is used in that program?
I haven't gone into those details yet. I would suggest, that's part of, this proceeding is to review not only North Carolina, but other jurisdictions in making that kind of determination and to weigh the pros and cons of the approaches.
Mm-hmm. Did you read the proposed guidelines that Mr. Levitas included in his exhibit SJL 11?
I have skimmed through it. There was a lot of material in Mr. Levitas's filing. Those set of guidelines I did have a chance to kind of run through.
Right. And you're aware that Mr. Levitas, according to Mr. Levitas, those are heavily based on the Duke CPRE process. Is that right?
Yeah, I understand this is from the Duke CPRE process, correct.
Okay. And were you aware that under those guidelines, the IA runs the process, but the utility personnel also participate in the evaluation of proposals?
Yes, I'm aware of that. That's striking a hybrid option. Trying to kind of thread the needle there to get the best of both worlds. I've also attempted to do this in the past. It's not extraordinarily practical to maintain, to adhere to certain protocols, like not disclosing the names of bidders and such. So I've just recently read this, so I haven't had an extensive, haven't delved into it as much as there's only been about a few weeks to review a lot of the exhibits and testimony.
Understood. Thank you. Would you, is it fair to say that under those processes, although an IA runs the program, the process leverages utility personnel and utility expertise in those important areas of evaluation?
I'd have to review every area that the utility is leveraged. There are a lot. And so, when I look at it, it's a question of, what benefit is the IA really bringing if they are running the process as opposed to the utility. I just personally find that I'm more effective as an IM to ensure consistency, to go across the board and review the evaluation scoring conducted by the utility, asking the right questions, the differences relative differences between bidders, and if there's a utility involved, between the bidders and the utility itself. And so in focusing the ask, in my view, to ensuring consistency across the board, I'm essentially have more focus on that than running a process. I don't see how just running the mechanics of the process would necessarily bring added transparency. The process itself is run, typically in any procurement, it's run according to a defined evaluation manual, which is one of the best practices I typically follow. Prior to the conduct of any RFP, you define what that process would look like, what are the steps that are taken, and that's where I get involved and ensure that that process manual is well developed. And as the utility conducts the evaluation process, I sort of check off to ensure that they're following along the predefined process that was established.
Did you hear Mr. Cassis testify earlier today that in his view, the CPRE program was a relatively successful program?
I'm not sure if he used those words exactly. I don't recall that.
Okay. Do you have a view on whether it has been a relatively successful program?
It's very hard to determine whether a program is successful without looking at a variety of factors. Whether the projects themselves have delivered value onto the system, have they modeled that? Has there been what level of projects have been actually realized? Costs versus what versus the avoided costs, that being the actual avoided cost on the system compared to the prices they were able to obtain. So there is a variety, a number of factors that need to be looked at.
Okay. And Mr. Kojak, in your rebuttal testimony, I'm looking at page 3 of your rebuttal testimony. You testify, I'll give you a minute if you need it.
Sorry, go ahead. Which page?
Page 3. You testified that as an independent administrator, I oversaw a CPRE process in which over 50% of the projects selected in a given round did not proceed to contract and dropped out. Is this 50% dropout rate, was that typical of the withdrawal rate of procurements where you've served as an independent administrator?
Yeah, there's typically a higher dropout rate with an independent administrator because it's following a process that unless there's a rigorous qualitative evaluation, you're able to really get into the different risk factors. A lot of times CPREs are set up, particularly where an independent administrator is involved, that does not go into the same level of depth as a utility-led process. And so that's, in my experience, has led to a higher dropout rate.
But 50% is that a typical dropout rate for IA run processes in your experience?
Yeah, it's anywhere between 20 to 50%, and it kind of varies in accordance with the number of factors. Sometimes projects are selected if the price is weighted highly and the process does not allow for qualitative red flags to disqualify a project. If a solicitation process is defined as such, then a low price essentially is what is shortlisted, and those projects are typically the ones to have a higher failure rate in comparison to others. So getting the design right in any procurement is important. It's important to consider those non-price factors, and just from my experience as an independent administrator, the projects the solicitations that call for an IA don't really prescribe or don't typically prescribe a significant amount of qualitative evaluation or ascribe a higher percentage weighting to the qualitative evaluation as a utility-led process.
Mr. Kojak, if you would, please take a look at its exhibit. Do you have Mr. Levitas' direct testimony handy?
I do.
Okay, and if you don't mind taking a look at exhibit SJL 8.
You're gonna have to give me a moment here to pull up that.
Sure. Yeah, I know it's a big.
There's a 1 of 2 and a 2 of 2. Is that?
Yeah, so one of 2 in that.
Okay.
And I'm looking at the very last page of that. So it's page 43 of the PDF, but it's marked as page 39 of the document.
Okay, I am
okay.
there.
And you see, are you with me?
Yes.
Okay, and you see under, I guess, Roman 13 finalists, second paragraph there. I'm sorry, I apologize, I should back up to this. This is, if you look at the second page of the PDF, this is the final report of the independent administrator for CPRE Tranche 2. Do you see that?
Yes, I see that.
Okay. Okay, so this represents the results of tranche 2 of the Duke CPRE program. Is that fair to say?
Let me just check. Yes, it appears so.
Okay, thank you. And going back to that last page, page 39, and I apologize for bouncing around here, but it says that in the second paragraph there, it says the 90-day process after selection was concluded on October 15, 2020. One finalist notified the IA on October 14th that it wouldn't execute a PPA and would forfeit proposal security. I'm paraphrasing here. And the last sentence says the withdrawal reduced the total megawatts under contract by 25 megawatts to 589 total megawatts for DEC. Do you see that?
I do see that. Yes.
Okay. And the paragraph before that discusses the results of the tranche 2 RFP for DEP, doesn't it?
I haven't read this prior to the, so I would have to read it now. Is there a specific question?
Okay. Yeah, I'm sorry. I'm asking you to look at this. So what I read here is that 11 proposals from DEC and 1 proposal from DEP were selected, but only 1 project that was selected did not sign a contract. Is that a fair reading of the second paragraph here?
Yeah, it states here that a project that did not sign a contract forfeited a $500,000 proposal security, which appears to be a rather harsh penalty in my experience for a 25 megawatt project.
That withdrawal reduced the total megawatts procured by 25 megawatts from 614 megawatts to 589 megawatts. Is that right?
Yep, that's correct.
Okay, so in terms
that's
of
what it reads.
Okay, so in terms of projects, that's about a 9% withdrawal rate, isn't it?
Well, that's 9% prior to contract. You know, I'm looking at the $500,000 proposal security, and if you have a high amount of security, you're gonna want to get to the PPA. You're gonna want to, try to get into contract and proceed. There are projects, in my view, that did not proceed. When I say 50%, it's not just before, but also after the contracts were signed. Issues come up at all points in the process that were not previously discovered.
Yeah, I mean, respectfully, Mr. Kojak, I don't think that's what your testimony says. I'm reading here, you testify that as an independent administrator, I saw a process where 50% of the projects selected in a given round did not proceed to contract and dropped out. Is that fair?
Yeah, that's fair. For one particular round, there was a fairly high dropout rate prior to contract. And there's a few developers in particular that were not able to secure. They had some site-related issues and other issues that prevented reaching or proceeding to contract. That's not only but in other rounds that I've seen, even where the dropout rate was relatively low, which I put at around 20%, there's been a lot of projects that have dropped out post-contract, and that's when they typically forfeit security, because when you go into contract, that's where in the programs that I've typically administered, security comes when you sign a contract. You have to post development security. To me, that's a better practice. It doesn't, and that's one of the many factors that should be considered as part of the design of CPRE, is when security should be instituted to ensure that you're getting, a project that you could rely on. That has the effect of barring a certain level of competition, particularly with smaller developers. So that's just one of many items that should be looked at in a process such as this that's looking to develop a CPRE program.
Understood. And are you aware of whether the contracts awarded under the North Carolina or the Duke CPRE program have large financial penalties for non-performance after PPA is signed?
I was not previously aware. As I've stated earlier in my testimony, I have not analyzed the North Carolina CPRE program. I've been involved in other jurisdictions.
Understood. Thank you. And with the understanding that this CPRE Tranche 2, I mean, this report is dated February 2021, so it's early days yet. But at least in terms of withdrawal rates, that 4% withdrawal rate compares pretty favorably to a 50% withdrawal rate that you've got for comparison, doesn't it?
Yeah, I think ultimately the proper measure is to see which is to check on the commercial operation of the units. So you want to see coming out of the CPRE program, have these projects achieved commercial operation? That would be a better metric to determine the success of the program.
Okay, thank you. Mr. Kojak, on pages 5 to 7 of your direct testimony, you testify about the use of competitive solicitations in conjunction with the state's implementation of PURPA. Is that right?
Yeah, that's correct.
And I take it you are familiar with the requirements that FERC has issued in regard to the use of competitive solicitations to implement PURPA?
Yes, I'm familiar with that.
Okay, and those would be in FERC Order 872, is that right?
I'm not 100% sure, but which FERC order it is, but I have a high level understanding of the order and its requirements.
Okay, understood. So that was the order that was issued, if it was last year, the so-called PURPA reform rule, is that right?
Right.
Would you agree that in that order, FERC provides the minimum requirements for the design and implementation of competitive solicitations as an alternative to traditional PURPA implementation?
Yes, that is my understanding.
Okay. And would you agree that one of these minimum requirements is the use of an independent administrator to help ensure fairness in the design and implementation of a procurement?
My understanding is that an independent administrator is called for when it is used to set the avoided cost rate, not in other circumstances.
Understood. But where solicitation is used to set avoided cost rates, FERC also specifically requires that a solicitation not be administered by the purchasing utility itself or its affiliates. Is that right?
If it is used to set the avoided cost rate, that is my understanding.
Okay, understood. So just to sum up, your position is that the Commission should permit unlimited utility participation in its own RFP here. Is that right?
That's correct. No cap on any party involved in the procurement.
Understood. And the Commission should not require appointment of an independent administrator, right?
That's correct.
Okay, because that's not practical?
I think it's not as ideal and not as beneficial when you're building out a system and you're trying to optimize the benefits to customers. I mean, with respect to the FERC, I understand that's specific to PURPA reform. What my testimony is about, it's about CPRE programs and how to align CPRE to deliver the maximum benefits to the customers. So that kind of diverges. I'd say I would distinguish that from the PURPA reform requirements. And so what I'm advocating for is a process that would maximize those benefits to customers. And one way of doing that is keeping the utility involved so that would evaluate effectively and comprehensively the contribution of renewable resources on the system.
Okay, so the important part of having an independent monitor, or rather the principal advantage of having an independent monitor, is being able to leverage those utility resources in doing those evaluations, right?
Yes, that's correct.
Okay. So Mr. Kojak, and we're getting just about at the end here, so I appreciate your stamina. You testify in your rebuttal testimony about the use of form contracts and procurements. Is that right?
That's correct.
Okay. And in your view, it's not advisable to approve a non-negotiable form contract, right?
Yes.
Okay. But to be clear, what you're recommending is development of a form contract, but allowing bidders the option to propose revisions to the contract that would allow for better pricing. Is that right?
Yeah, that's correct.
Okay. And you're not recommending that there be no form contracts at all?
There should be a pro forma contract in a competitive procurement process. That's kind of the original, the general agreement that the utility would execute with the developer. That gives them an idea of what the overall terms and conditions of the deal would be.
Mm-hmm. Do you think that there should be any terms of the contract that should be non-negotiable?
You know, in another jurisdiction where we've taken that road, developers have indicated that there's, have indicated that there are terms in every part of the PPA that they may need to comment on or adjust slightly, and it varies from developer to developer. So I do not believe any part of the PPA should be necessarily locked down, but as part of the qualitative evaluation, if the developer is proposing terms that go beyond, essentially transfer the balance of risk entirely onto the utility, if it's assessed that the changes are too material and it does not reflect the original bargain or intent, then they may be either disqualified or they would receive a very low qualitative evaluation score, which would disadvantage them in the process.
Thank you. So going back to Mr. Levitis's testimony and the recommended guidelines in SJL 11, you read the guidelines, you mentioned them in your rebuttal, but other than what we've discussed here, you don't provide any specific critique of Mr. Levitis's proposed guidelines, do you?
The ones in SJ 11?
Right.
So, I mean, there are a number of items in SJ 11 that are important to discuss. This, for example, prescribes the independent administrator approach. That is an item that should be discussed at length with stakeholder input. This also sets the contour of the entire program. So it's essentially prescribing a particular design. I don't tend to agree that any particular set of guidelines is a right answer. I think, the design for any particular jurisdiction should be discussed with stakeholders in that particular jurisdiction in this state. And that includes developers, the utilities, customers. Customers should always be represented. That is, in my view, a best practice. I don't think these are plug and play. I think there's a fair amount of work that needs to be done to align it. There's for example, a section on interconnection, the interconnection process. I don't know if that certainly that may or may not be compatible with this particular jurisdiction. So there's, I guess what I'm trying to say is there's a fair amount of work that has to go into the development of these kinds of guidelines, and I think that would be one of the findings potentially coming out from these kinds of hearings. In my experience, these are items for further discussion and exploration.
Anything else, Mr. Snowden?
Sorry, thank you, Mr. Chairman. No, I have no further questions. Thank you. Thank you, Mr. Kojak.
Thank you. Take care.
Cypress Creek Renewables, Echoplexus, Southern Current.
No questions, Mr. Chairman.
Johnson Development Associates.
No questions, Mr. Chairman.
South Carolina Coastal Conservation League, Southern Alliance for Clean Energy.
Thank you, Mr. Chairman. We have no questions.
Office of Regulatory Staff.
Thank you, Mr. Chairman. No questions for us.
All right. Commissioner questions for this witness. Commissioner Powers.
Thank you, Mr. Chairman. I just have a couple of questions, Mr. Kojak. On page 6 of your testimony, I think you've been questioned about it in another way. Line 17 through 20, you say that working with other utilities have high levels of renewable penetration and PURPA contracts, just like Dominion Energy South Carolina. You've seen state policymakers, regulators effectively implement CPRE in conjunction with PURPA reform policies. So, number one, DESC does have the capabilities, certainly the number of contracts or renewable penetration to consider such a program, do they not?
A CPRE program, Commissioner?
Yes.
Yes, I would agree with that.
Okay. And have you worked with any state legislatures or groups as far as making any sort of reforms to PURPA?
No, not particularly, no.
Well, how can we as a state commission reform a federal mandate?
Well, this, I think what I was trying to say here, Commissioner, is that a CPRE program could complement PURPA to provide an alternative avenue for procurement of renewable energy, potentially at a better rate, a rate that is lower than the avoided cost. I would agree that, well, and further, I believe there's there could be, as far as I understand, some opportunity that's afforded under PURPA more recently. And again, I'm not familiar with this. I'm more a procurement subject matter expert. But there's a way to integrate CPRE with under PURPA to an extent.
Can you name any specific state or any example where there has been reforms done to PURPA policies that you've been involved in?
I have not engaged in PURPA reform, Commissioner.
Thank you, sir. Thank you, Mr. Chairman.
Commissioner questions for this witness.
Chair Wade.
Commissioner Caston.
Good afternoon, Mr. Kojak. Can you hear me okay?
Yes, I can. Good afternoon, Commissioner.
Thank you very much. Early on in your statements, I think you said something about stakeholder groups could help the process. Is that correct?
Yes, that's correct.
So do you believe a broad range of stakeholders could or should be used to help the process and outcomes?
Yes, I do believe that. I've seen in other jurisdictions where similar docket has been established. There are working groups to discuss these matters. Several meetings are held over a period of time to discuss each item and to collect the comments and to make the appropriate determination as made by commission staff and commissioners.
And I think in one of your last answers or responses to Attorney Snowden was something to the effect, in your opinion, customers should always be included in the stakeholder process. Is that correct?
Yes, that's correct.
some process for some customer representation. And in our case, I think that typically falls to the Office of Regulatory Staff, but I'm not sure there are any customers per se that are involved or even questioned. How do you think that should be addressed?
So I've seen at times there have been representatives from, larger customers being involved in these kinds of proceedings. I've seen rate counsel, depending on the state, they've effectively represented customers. As long as the the interests of customers are represented, particularly on the cost side, is the key interest by many customer groups, ensuring that these kinds of programs are delivering benefits to the grid on a cost and reliability basis. That's I think that's always a good perspective to have when in proceedings like this.
Thank you. One final question. In your testimony, you state to ensure cost effectiveness, a CPRE must address a clearly defined system need at a lower effective cost to customers. Are you saying that if you're going to have a CPRE, it needs to do that at a minimum? Am I understanding what you're saying there correctly? I think that's page 4, lines 17 through 18.
Could you restate that, Commissioner, with respect to
page 4? Are you saying it was in response to a question what non-price factors should be considered to ensure CPRE is cost effective? What I'm asking, I guess in a broader sense, is you're saying to ensure cost effectiveness, a CPRE must address a clearly defined system need at a lower effective cost to its customers. If the CPRE does not do that, are you saying that, is that part of it or the gist of it as far as the CPRE?
Yeah, in my view, the CPRE should not, result in selections unless it meets these two tests. Is there a driving force behind it? Is there a need typically studied under the IRP, which suggests integration of a certain amount of renewables is beneficial? If you have that finding, and then also what is the optimal timing? Because it's essentially you don't want to put a resource in place several years before actual need. You would be paying extra costs up front without being able to kind of maximize its benefits. So aligning the install date is an important factor there. So cost effectiveness, talks about, it addresses the price as one element, but there's other value driven by resources that's dependent on where it is on the system, what are its capabilities that it could deliver, and that ultimately, if the utility models that resource, it may have a greater level of benefits than potentially as compared to a project that has a lower cost but lesser benefit. So that comparative evaluation needs to be conducted, and a lot of times these questions are assessed and answered in the context of an IRP. So the IRP is an important, to me, it's like a guide rail. It ensures that here's a path that has been assessed, has been modeled, it works. It keeps you within certain bounds to ensure that there isn't a situation where renewable energy is over procured or procured before the date of need where it could actually be effectively monetized. If it's procured too early, you may have additional curtailment. If it's procured in a wrong location, if it's in a location where may interact with other resources that also drives curtailment and reduces the value not only to Dominion, but also the developer. So these are all factors that should be evaluated thoroughly. And I believe, and that's part of the rationale to having an IM, is to give the utility the full picture of the resource so that they could effectively model it and see how it interacts on the system using the tools and capabilities that they have in-house.
Okay, let me make sure I understand that or try to sum it up in a lump if I can. The CPRE is basically a process to try to get competitive bids or projects for these things, but the driver for a good CPRE is an adequate plan by the utility to have a good understanding of where it is best to do things, because the cost, this may be a lesser cost, but for the needs that are required in this part of the system and the upgrades that would be required, this is a better system here rather than in this place over here. Did I kind of understand that correctly?
Yeah, that's, I would agree with that. That is a key element. It's to control the build out in a way that ensures resources are going in the right locations, the optimal locations. And, you know, a lot of times the IRP may not state that this is the best location, but it'll give you a rough idea of how many megawatts can be integrated. And in the context of the RFP itself, projects are evaluated based on those, based on these other factors, these other non-price factors. And so location would contribute to that particular project's contribution to the system. If an IRP can, if necessary, identify a particular location where there's an acute need, and a procurement can be designed such that it meets that particular need on the system.
Okay, and I must be honest, before I came on this commission, an IRP, I'd never heard the term. You know, not a term that we typically use. What I had heard and what we were familiar with and what I was familiar with was long range and short range master plans, which considered all those things, which considered demands, growth, population growth, which was linked to demands. Where was that demand probably going to occur, and what infrastructure, what resources, what needed to occur to start accommodating that? It sounds to me what you're talking about is really more a strategic long-term and short-term master plan that is geared toward a CPRE. An IRP is just a 3-year plan. I mean, to me, that's great, but planning for 3 years, it's not in my view, the best way to determine how we're going to spend tens of millions of dollars or however much it is. True or false?
I've had a chance to review the IRP kind of in high level detail. It has resource additions from 2026 through 2049. I agree with your characterization. It's a master plan. It should, that's the idea of an IRP. And you know, that's really, you know, that plan, that study that's conducted provides, you know, the bounds that a CPRE should follow. I can't comment beyond that. I've only reviewed the IRP on a high level. It seems to include a fair amount of solar and other resources throughout the 23-year horizon. And, you know, that's, if this is the optimal path, that's how you would style the CPRE. It's to procure these resources in accordance with the planned additions here.
All right, thank you. And it's, as I was reminded that RRP, I think, is their 15-year plan, the utility's 15-year plan updated every 3 years. So if we're saying that the RRP is and can and should serve as a strategic master plan, looking out that period of time, it's updated every 3 years. Then that makes sense relative to what I'm understanding you're saying would be needed to really guide a good CPRE. Correct?
Yep, that's correct.
All right. Thank you, Mr. Kojak. Is it Kojak or Kojak?
It's Kojak.
Well, you have a lot of hair for a Kojak. But thank you. I want to make sure I got that right. Thanks, sir.
All right, folks, we're in recess until 3:35. Ladies and gentlemen, we're back at the Public Service Commission in docket number, Public Service Commission of South Carolina in docket number 2019-365E. We're going to take roll. Here in the hearing room, we have Commissioners Powers, Thomas, Vice Chair Belzer, and Chairman Williams. Joining us virtually, we have Commissioner Williams, Commissioner Caston, and Commissioner Irvin. We just finished with Commissioner Caston's line of questioning before we broke. Any more commissioner questions?
Mr. Chairman.
Commissioner Irvin.
Thank you, sir. Mr. Kojak, how are you this afternoon?
Good, Commissioner.
Appreciate your patience with us. One thing that I wanted to ask you about in terms of process is that after listening to the testimony so far, it appears that the real driver for this entire process is the IRP. Would you agree with that?
Yeah, yes, I would agree. The IRP would be the key driver to a CPRE.
And I'm just wondering whether or not we may have gotten the cart before the horse, so to speak, looking at the competitive process before we actually settle on an IRP for Dominion and the other utilities. What do you think about that?
Commissioner, I don't disagree with that assessment. I think you have to settle on a plan, and then based on that plan, you structure the CPRE process in accordance with that.
And so it's kind of like in a football game, to use a sports metaphor, you would develop a game plan first before you give a play call sheet to the offensive coordinator, right?
Yeah, I would agree with that analogy.
Good. And so I'm just wondering, I don't know what expectations are, but I'm just wondering in terms of the process, wouldn't it really be kind of premature for us as a commission to do much at all with competitive process at this point in the game?
I think, sorry, I'm getting some feedback. At this point in the generic docket, I think we could explore different designs, best practices, kind of get an idea of what a CPRE process could look like. I think, as mentioned previously, there are a number of decisions and discussions that need to be had to fully flesh out and develop a CPRE process. And the timeline, as you correctly suggest, is driven by the IRP determination of what the need date is. And you kind of back up from there to allow time for the procurement process to be conducted and the construction EPC process to follow that. That's what would drive the the need to go out and fully flesh out a CPRE process. So I would agree with that assessment.
That's a great segue into my follow-up question, which is if, for example, Dominion, I believe their first procurement in their revised IRP is 2027. Does that sound about right?
I believe it's 2026.
Okay. So as an independent manager or planner, when would you advise this commission to begin looking at a competitive procurement process, knowing that one of our utilities is going to be going out in 2026 for additional portfolio needs?
So the procurement for a 2026 resource would probably be around 2 years, 2 to 3 years prior to the need date. Depends on the scale of the resource. In this case, it's a 50 megawatt resource. I think by this procurement would have to be run by 2024. Certainly something I would explore with the developer community to see what they believe is a feasible timeline. But in my experience, 2 years for a 50 megawatt resource is sufficient.
Okay.
gives about 6 months plus 18 months CPC
Right.
time.
And as a part of that run-up in that process, I've heard you talk about the importance of getting stakeholder and buy-in and involvement. Would that be a part of the run-up as well, to try and reach out to stakeholders and developers and say, okay, we're ready to look at this process, let's get together, share ideas?
Yeah, I would suggest using this time in the next couple of years to fully flesh out a lot of these issues. You have, the 50 megawatts, of course, in 26 and 27, but it appears there's also a series of procurement starting from 2030 thereon of 100 megawatt tranches. So to properly set up a CPRE, get buy-in, structure it, I recommend involving all the right stakeholders, the developer community, the utilities, customers, members of commission staff, commissioners also, involved in this to structure it proper.
Very good. And one thing I noticed in the correspondence leading up to this hearing today was that both Duke and Dominion thought it best if they had their own separate dockets. That probably is the best path forward, don't you agree?
That I believe so, because when you're structuring a procurement program, it is utility specific, utility service territory specific. It addresses the specific needs identified in an IRP. And no utility is going to be the same, and no jurisdiction is going to be the same for that matter. So there's probably elements that could be borrowed across the two, but when you're going out and procuring a certain set of resources in accordance with the established needs that was studied, that I think would be best handled for aligned with that specific utility. So I'd agree with you.
So we don't need to have another generic proceeding. We need to actually take, for example, Dominion's IRP, and then at the appropriate time in your timeline, trigger that process of gathering stakeholders and beginning to develop the competitive procurement for Dominion, correct?
Yes, that's correct.
And there'd be a similar parallel path for Duke and other utilities as needed, right?
Yes, and this is typical across the industry and with respect to different commissions. This is the process that is followed.
Okay, so since you've been through this process in other jurisdictions, and since this is the first time we've had a chance really to look at this particular aspect of Act 62 in South Carolina, would you agree that any kind of final order or in this particular generic proceeding really just needs to be very general in terms of a path going forward?
Yeah, my understanding is that this is exploratory. Next steps should be generally defined. I don't think any near-term determinations can be made given the complexities involved. So I tend to agree with you, Commissioner.
Well, you've been most helpful, and I appreciate your testimony today. Thank you. That's all the questions I have, Mr. Chairman.
Thank you, Commissioner Urban. Any more commissioner questions? All right, hearing none, redirect. Hearing no redirect.
Sorry, Mr. Chairman. This is Ashley Cooper, but Dominion, it took me a second to get it off mute. No, we do not have any redirect at this time. Thank you.
All right, sir. Mr. Kojak, you can step down from the witness stand and be excused. Mr. Cooper, please call your next witness.
Mr. Chairman, this is Will Middleton on behalf of Dominion Energy South Carolina. Dominion Energy South Carolina next calls Laura Mans to the stand.
Thank you, Mr. Middleton. Ms. Mans, if you would take the stand and pause for a brief second to allow the court reporter to swear you in.
Ms. Mans, if you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you very much.
Thank you, Ms. Mans. Please state your name for the record.
My name is Laura Mans.
And by whom are you employed and in what capacity?
I am employed by Guidehouse in the capacity of Director, Power Delivery Solutions.
Thank you, Ms. Mans. And have you prepared or caused to be prepared under your supervision direct testimony of 9 pages that was previously filed with the Commission on February 22nd, 2021 in this docket?
Yes.
And Ms. Mans, do you have any changes or additions to your pre-filed direct testimony?
No changes or additions. Thank you.
So if I asked you the same questions here today, would your answers be the same?
Yes, they would.
Thank you, Ms. Mans. Mr. Chairman, at this time, I move that the pre-filed direct testimony of Ms. Mans be admitted into the record as if given orally from the stand.
The pre-filed direct testimony of Ms. Mans will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. And Ms. Mans, have you prepared or caused to be prepared under your supervision one exhibit to that direct testimony labeled as exhibit number LM1 that was previously filed with the Commission as an attachment in this docket?
Yes.
And do you have any changes or additions to that exhibit, Ms. Mans?
No.
Thank you, Ms. Mans. Mr. Chairman, I would also move into the record as the next hearing exhibit, the exhibit attached to Ms. Mans' direct testimony and labeled as exhibit number LM1.
Exhibit number LM1 will be marked and entered into the record as hearing exhibit 1.
Thank you, Mr. Chairman. And Ms. Mans, have you prepared a summary of your direct testimony?
Yes.
Would you please deliver that summary at this time?
Yes. Good afternoon, Chairman Williams and members of the Commission. My name is Laura Mans. I provided direct testimony in this docket on behalf of Dominion Energy South Carolina, Inc. on February 22nd, 2021. And I respectfully request to provide the Commission with a summary of the same. I am employed by Guidehouse, Inc. as a Director of Power Delivery Solutions. I have over 35 years of experience in the electric power industry. I'm a certified power grid dispatcher and have managed transmission planning and resource interconnection for decades. At Guidehouse, I work with clients around the globe on system operations, electricity markets, transmission and distribution planning, and regulatory policies. The purpose of my direct testimony is to address issues raised by the Commission related to the impacts of CPRE on areas such as interconnection and integration of energy. Assessing these other impacted areas is important because a best practice for evaluating CPRE proposals includes also evaluating the net benefits of a project, which must account for costs of infrastructure to interconnect and deliver resources selected under a CPRE, areas affected by corresponding interconnection policies. As for the interconnection process, most utilities maintain a serial study process, which utilizes a first come, first serve approach to study the impact of a project has on the grid and assign costs. However, this can be a lengthy and difficult process, which has the potential to delay viable projects while shifting costly upgrades to projects later in the queue. On the other hand, a number of utilities study projects in clusters. As with the serial process, cluster studies utilize a first come, first serve approach. However, contrary to the serial approach, the cluster study process permits certain costs to be equitably shared by groups or clusters of interconnecting resources. This approach can improve efficiency and reduce the number of restudies and reallocations of costs so that ready projects can be advanced. The cluster study approach ensures that resources in close proximity of each other are studied together to identify the most cost-beneficial infrastructure upgrades. This cluster study process can also be designed to accommodate storage. Given that storage operates differently than intermittent solar and can act as both a load and a generator, engineers must necessarily conduct additional modeling and study storage under various scenarios to obtain an accurate picture of the benefits storage could provide through a CPRE process. The interconnection reforms necessary to implement the CPRE process can be time-consuming and costly, and any such reforms must be guided by the regulatory process. Even after RFPs are issued, it can take almost 2 years to identify reliability impacts and the additional infrastructure that would be required to accommodate successful projects. Additional resources may be required to identify these impacts, such as additional engineers or administrative resources. However, many areas in the U.S. have initiated such reforms, and several best practices have emerged to address the processing of interconnecting CPRE resources. These include an open window for all resources to identify their technical parameters for study, sufficient time to validate resource data and close any information gaps prior to study launch, withdrawal penalties to discourage speculative projects, study resources simultaneously with defined time periods to obtain results, timely preliminary findings for resources to receive preliminary interconnection and integration resource infrastructure estimates. Resources are afforded the ability to exit the process at predictable stepping off points. Complex studies are conducted later in the process to avoid time delays and reduce costs of restudy. Resources share costs under a beneficiary's pay approach based on a resource's proportional contribution to the need for infrastructure upgrades, and it allows ready resources to operate on an as infrastructure is available basis to deliver the resource until all upgrades are complete. I thank the Commission for its time, and this concludes the summary of my direct testimony.
Thank you, Ms. Mans. And have you also prepared or caused to be prepared under your supervision responsive testimony of 2 pages that was previously filed with the Commission in this docket on March 1st, 2021?
Yes.
And do you have any changes or additions to that pre-filed responsive testimony?
No changes or additions.
Thank you, Ms. Mans. So if I ask you the same questions here today, would your answers be the same?
Yes, I would.
Thank you, Ms. Mans. And Mr. Chairman, at this time, I move that the pre-filed responsive testimony of Ms. Mans be admitted into the record as if given orally from the stand.
The pre-filed responsive testimony of Ms. Mans will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. And Ms. Mans, have you also prepared a summary of that responsive testimony?
Yes, I have.
And would you please deliver that summary at this time?
Yes. In my responsive testimony, I agree with witness Cersei's statement that CPRE guidelines should account for a utility's specific characteristics, such as the penetration level of solar PV on the grid. For example, utilities with higher levels of renewable penetration should include curtailment provisions in their CPRE guidelines, given the increased likelihood of oversupply. CPRE guidelines should also account for a utility's specific operating standards and requirements that may impact reliability as informed by the utility's integrated resource plan. As the Commission noted, this is a complex matter that could potentially impact a number of other dockets, such as the avoided cost docket, where the foreign PPA was established, the ongoing integration study docket, and the ongoing interconnection docket. Although this is a generic proceeding and meant to explore these issues broadly, any final decision by a utility to move forward should more thoroughly consider and address these issues. I thank the Commission for its time, and this concludes the summary of my responsive testimony.
Thank you, Ms. Mans. Mr. Chairman, Ms. Mans is available for cross-examination by the other parties and questioning by the commissioners.
Thank you, sir. Duke Companies.
No questions for this witness, Mr. Chairman. Thank you.
Carolina's Clean Energy Business Association. Mr. Snowden.
Oh, I'm sorry, Mr. Chairman. I was double muted. We just have a couple of questions for Ms. Mans.
Please proceed.
Thank you. Ms. Mans, good afternoon. It's very nice to see you.
Nice to see you.
Ms. Mans, in your direct testimony, you talk a bit about the interconnection process. And as you said in your summary, after projects are selected in a hypothetical CPRE program, it would take almost 2 years to complete the interconnection study of those projects. Is that right?
That's correct.
And you have specifically considered the state of Dominion's interconnection processes in saying that, haven't you?
I'm familiar with some aspects of their interconnection process, which is a serial process currently, where one project is studied at a time. When I talk about timely, things that would take a long time, it's not only the serial process, but also a grouped process. Either of those can take a long time.
Okay, so however the process goes, it can take up to 2 years to identify impacts. Is that right?
Yes.
Okay, and then it could take also, if upgrades are required, it could also take a number of years to complete those upgrades, couldn't it?
That's true. It could take some years to construct them.
All right, so when thinking about how much time it would take to get from the selection of projects all the way to commercial operation, you might be looking at 3 to 4 years, given the state of interconnection. Is that right?
That's true, and that's a best case assumption, right? Because it assumes there isn't a bunch of projects in front dropping out and then imposing their costs, especially for in the serial study process, right? They impose their costs on the next project, and then that project might drop out, and then those costs accumulate the next one. So yes, there's the ideal situation, assuming you don't have a lot of withdrawals and dropping out, would be that it could take up to 2 years to study, and then considerable time, probably, well, it depends on the upgrade, but more years to get that done.
Okay, understood. So it's probably not realistic to assume that we can initiate a procurement and get from the beginning of the process all the way to commercial operation in like 2 years, right? That doesn't seem realistic given what you said.
Well, it depends, right? So what I think my colleague was talking about the design of the procurement, that he thought it could take 2 years. The design of the queue processing is almost a separate effort. I mean, it's considered, has to be considered as part of the procurement, but it runs on a parallel track, and actually in some cases those things are done ahead of time. So resources understand the interconnection process. They understand that the regulations are either a serial process or a cluster study process, and what process would be applicable. And then, of course, to further complicate it, there are the state processes and then the federal processes that also have to be harmonized.
Okay, understood. But we've got to design the procurement before projects can be selected and interconnection can be studied for those projects, the win, right?
I want to make sure I understand that I'm talking about the interconnection process separate from the design of the procurement, right? Mm-hmm. So if you understand the interconnection process, it would inform the design of the procurement. They don't necessarily have to be completely separate and sequential. They do have to work together.
Okay, understood. But let's just say, working back from, if we have, if the resource plan shows that it's economical to be adding renewable resources in, say, 2026, then working backwards from there, if it takes 4 years to complete the interconnection process and constructing upgrades, we're talking about having a project selected in 2022 to achieve that 2026 online date, right?
I think if I go back to what my colleague said, it's 2 years for that procurement process. Designing the interconnection process can happen now, right? So queue reform can happen now. It doesn't really change when you need to start your procurement process. It's just how many things you have ready. And so it's best to have your interconnection process ready and understood and clear when you do your 2-year forward procurement design, as Dean Kujak said.
Understood, thank you. But just given the amount of time it takes to actually achieve interconnection, if we're hoping to put projects in service in 2026, these procurement issues and interconnection issues are things that we should be thinking about now, aren't they?
Well, procurement issues separated from interconnection issues, there are some things to think about, right? So where my resources are interconnecting, it may be a very fast process. If I have, for example, ideal case, a cluster study process, units know like how the process goes. They're ready with their information. They're ready to be processed, and they're locating in good locations that you don't really need a lot of upgrades. You know, that could be that you could roll that forward in the 2-year time frame that my colleague talked about. So I want to differentiate the processes separate from the procurement.
Okay. All right, thank you very much. No further questions.
Thank you.
Cypress Creek, Exoplexus, Southern Current,
No questions, Mr. Chairman. Thank you.
Johnson Development Associates,
This is Corey Walsh from Johnson Development. No questions.
South Carolina Coastal Conservation League, and Southern Alliance for Clean Energy.
No questions, Mr. Chairman.
Office of Regulatory Staff.
Thank you, Mr. Chairman. This is Chris Huber for RS. We have no questions for this witness.
Thank you, sir. Commissioners, questions for this witness? Hearing no.
Chairman Williams?
Commissioner Williams.
Thank you. Good to see you, Ms. Mance. Thank you for your testimony and in this particular relevant area. I am curious what states have reformed the interconnection process to support the CPRE process.
So I'll mention a few. I may not have them all, and I will focus on the states that don't have an ISO or an RTO. So New Mexico was, I think, one of the first. We've worked with Colorado as another state. There's queue reform that's gone on in Carolina and currently under discussion in South Carolina. Also trying to remember if it's Pacific Core, and I can't remember if it's their which part of their company. It's either in Utah or anyway up in that Pacific Northwest region.
Are there any that, based on the testimony and the questions that you've heard today, that you would recommend that we look at to learn from?
So the ones that are all informing each other at the moment are Colorado and North Carolina. I think, and New Mexico probably would be useful, but I would focus on Colorado and North Carolina. What's interesting to me about Colorado is that they've done their queue reform, tried to align it to the CPRE. They're now actually going through what I call the shakedown cruise and realize that there are still some adjustments to be made. So I think there are lessons to be learned there. And then also in North Carolina, as the independent administrator started going through the CPRE tranches, they had some recommendations and findings about the queue reform in North Carolina also.
Thank you. Appreciate it. No more questions, Chairman Williams.
Commissioner, thank you, Commissioner Williams. All right. Any redirect?
Chairman Williams.
Oh, Commissioner Caston.
Very quickly, I apologize for getting in late. Ms. Mance, can you hear me okay?
Yes, I can.
Good. Looking through your testimony and listening to your summary of it, basically you primarily talk about interconnections and I guess looking at storage, certainly requiring generation in both directions. So, those things need to be studied. As I kind of look at this in totality, it still seems to be, at least to me, the recurring theme that all these things need to be considered. And when you speak of a cluster study, I think I understand that to mean look at, I guess, areas again, which would still tie back to a master plan of sorts to see what infrastructure improvements, what interconnection changes, modifications are going to be required so you can determine those things and do projects in groups for the benefit of the system and groups, I would assume. Is that kind of right?
Yes, that's correct. And there's a couple of ways to slice and dice the groupings. So it can be on a time base. And so you open a window for interconnection applications and then close it, and then look at all the applicants in that window, and then look at which ones were electrically connected and group them both on a time basis and on a geography basis. And that way the costs are shared, and unlike the serial queue, as I was saying, all the costs are on the first organization in line. If they decide to drop out, then all the costs are imposed on the second organization in line. And so this grouping study allows costs to be shared, and gives you kind of a smoother way to get through the process. And it avoids that sort of downward spiral. If one drops out, you may have many drop out. And then it makes a lot of restudies. So it also increases the time to process.
So it still sounds to me, and I don't want to put words in your mouth, but it sounds to me as though before we really finalize or really get too much in the weeds on a CPRE, these are the kind of things that need to be looked at, answered, and planned. So if we do a CPRE, it can be developed accordingly.
Yes. So I'll just take an example that, understanding whether you're going to study these one at a time or study them in a group will directly impact how you would design your CPRE procurement in the first instance, right? So you might have somebody who's first in line, and then they have to get out of line to go be part of the CPRE. And if they don't win, do they get back in line, or do they go to the end of the line? There's all these little details about connections and interconnections that it's helpful to have them known before you start the procurement, because then you kind of lower that risk as you're looking at companies submitting their proposals.
Good, and I see how you tied that in with storage too, that since you have electricity going in, electricity going out, that's pertinent and relative to where you put it, and it needs to be studied how you do it. Is that what you're saying?
Yes, and there's two aspects. One is, the groups that I talked about, but then there are further scenarios that need to be studied when you look at storage, right? Because if you're just studying solar, it's got a pretty predictable shape to it. You know when the sun comes up, generally, when the sun goes down, generally. But as you're looking at storage, then you have to look at, I could charge any particular day, time of day, time of night. I might have a different impact in the winter versus the summer. So there's a few different scenarios. They're all studies that engineers know how to do. So I don't want to say it's simple, but it's known and it's straightforward.
Yes, ma'am. Thank you. I actually found that very interesting reading it, and very good. Thank you.
Thank you.
Thank you very much. And that's it, Chairman Williams. Thank you.
Thank you, Commissioner Caston. Redirect for this witness.
Mr. Chairman, this is Will Middleton on behalf of Dominion Energy South Carolina. We have no redirect for this witness, and this concludes Dominion Energy South Carolina's presentation of witnesses. Thank you, Mr. Chairman.
Thank you, Mr. Middleton. Ms. Manns, you may be excused. Thank you for your testimony.
Thank you.
Are the Duke companies ready to proceed?
Good afternoon, Mr. Chairman. The Duke companies are ready to proceed whenever you guys are.
Ms. Doolin, please call your first witness.
All right. The company's first and only witness today is Mr. George Brown.
Mr. Brown, if you would, take the witness stand, pause for a brief moment to allow the court reporter to swear you in.
If you would raise your right hand, Mr. Brown. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much.
Thank you, Ms. Wheat. Mr. Brown, will you please state your full name for the record?
Yes, my name is George B. Brown.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Corporation, and I'm General Manager of Strategy Policy and Strategic Investment for Renewable Policy.
Mr. Brown, did you cause to be pre-filed in this docket direct testimony consisting of 23 pages?
Yes, I did.
And do you have any changes or corrections to your pre-filed direct testimony at this time?
No, I don't.
So if I were to ask you those same questions that are contained in your direct testimony today, would your answers be the same?
Yes, they would.
Mr. Chairman, I'd ask that Mr. Brown's pre-filed direct testimony be entered into the record as if given orally from the stand.
Mr. Brown's pre-filed direct testimony will be entered into the record as if given orally from the stand. Ms. Doolin, if you would allow me to address some background noise that we're hearing in the hearing room. I'm not sure if that's coming from Mr. Brown or someone else who does not have their microphone muted. To help us out here, particularly our court reporter, if you would mute your microphone when you're not speaking. If you happen to be on the witness stand, it may be somewhat cumbersome to mute and unmute, but I think to facilitate a clean record, when you're speaking, unmute your microphone. When you're not speaking, mute your microphone. That may cause you to have to pause for a second before responding and or answering a question or asking a question, excuse me. Thank you. Ms. Doolin, please proceed.
All right, so Mr. Brown, yes, thank you. If you'll mute your mic when I'm speaking and we'll rotate back and forth like that. Thank you, Mr. Chairman, and just let us know if you continue to get some background noise and we can continue to recalibrate. So continuing, Mr. Brown, did you also cause to be pre-filed 2 exhibits, Brown Exhibit 1 and Brown Exhibit 2, with your direct testimony?
Yes, I did.
And do you have any changes to those exhibits at this time?
No, I do not.
Mr. Chairman, I would ask that Mr. Brown's pre-filed exhibits be entered into the record and marked as the next hearing exhibits, please.
Brown Exhibit 1 and Exhibit 2 will be marked as a composite exhibit and entered into the record as hearing exhibit number 2.
Sorry, trying to unmute. Thank you. Mr. Brown, did you also cause to be pre-filed in this docket responsive testimony consisting of 9 pages?
Yes, I did.
Do you have any changes or corrections to that responsive testimony at this time?
No, I do not.
If I asked you the same questions contained in your responsive testimony today, would your answers be the same?
Yes, they would.
Mr. Chairman, I'd ask that the pre-filed responsive testimony of Mr. Brown be entered into the record as if given orally from the stand.
The pre-filed responsive testimony of Mr. Brown will be entered into the record as if given orally from the stand.
Thank you. And Mr. Chairman, in lieu of a long summary, Mr. Brown and I are going to walk through his direct and responsive testimony at a very high level in a Q&A format. I've let other counsel know that we intended to do this, and I don't believe there was an objection to that.
Please proceed.
So, thank you. Mr. Brown, could you tell the commission a little bit more about your responsibilities for Duke Energy Carolinas and Duke Energy Progress, especially as they relate to Act 62 and the development of the North Carolina House Bill 589 and the North Carolina CPRE program? George, you're still muted.
Okay, sorry about that. As part of my job responsibility, I am responsible for any legislative efforts that are done in the Carolinas or any of our other jurisdictions for that matter regarding renewable energy. And I was involved in both Act 62 and HB 589.
Thank you. And could you describe what the purpose of your testimony is in this proceeding?
The purpose of my testimony is to describe for the Commission the various factors that should be evaluated when considering the creation of a program for the competitive procurement of renewable energy, and to provide information on DEC's and DEP's experience with the North Carolina Competitive Procurement of Renewable Energy Program, which I generally refer to as the North Carolina CPRE program.
Could you please provide the Commission with a little bit of background on North Carolina House Bill 589 and the North Carolina CPRE program?
Yes. North Carolina House Bill 589, which I will refer to as HB 589, was enacted by the North Carolina legislature in 2017. In part, HB 589 sought to reform North Carolina's implementation of PURPA by using market competition to drive solar investment rather than relying on avoided cost rates set by the North Carolina Utilities Commission. HB 589 ensures a traditional PURPA option is available to solar developers, but incentivizes new renewable development through the CPRE program option by providing the opportunity for longer-term contracts that are more attractive to the solar industry than what would otherwise be available under PURPA.
And what is the status of the North Carolina CPRE program?
There have been 2 tranches of procurement that have sourced a total of 1,185 megawatts, combined between Duke Energy Carolinas and Duke Energy Progress. It remains to be determined by the North Carolina Utilities Commission whether an additional procurement will be needed to meet the total procurement goals in HB 589.
Mr. Brown, what do you believe are important factors that should be evaluated in considering a competitive procurement program?
The creation of a competitive procurement program is time-consuming and requires a number of decisions to be made by the legislature or utility commission, as applicable, in order to establish, implement, and oversee such programs. As my direct testimony details, I believe the following issues are important in considering a program for the procurement of renewable energy: the purpose of the program, the volume of renewable energy to be procured, the timeline for procurement, the length of term for PPAs, the rate to be paid by customers, including whether a cost cap is used, the geographic location of the resources, the collection of costs for power purchase agreements and program expenses, utility operational control and economic curtailment, of non-utility owned generation, utility ownership, and whether the program is administered by the utility or a third party. My pre-filed testimony goes into further detail about each of these issues.
Do you believe the programs for the competitive procurement of renewable energy are beneficial for customers?
It depends on how you define beneficial. Customers will save money when the price of the power purchased under the program at the time it is generated is less than what customers would otherwise pay for purchased power in the spot market or the fuel and variable operating costs of other generation at that time. It is also possible that the contract price will be greater than the spot price of power at any given time in the future, in which case customers will be paying a premium for the contracted power.
Mr. Brown, what is the purpose of your responsive testimony in this proceeding?
My responsive testimony addresses certain points raised by the other witnesses who filed testimony in this proceeding. Given the very limited period of time for parties to submit responsive testimony and the volume of testimony filed by other parties, my responsive testimony only addresses a small portion of issues raised by those parties' witnesses.
What is your general impression of witness Levitus's testimony?
I find witness Levitus' testimony rather perplexing, as much of his testimony opines on issues that are beyond the scope of this docket as set forth by the Commission in the Directive, and some would require substantial changes to South Carolina law in order to be implemented. As to the relevant portions of witness Levitus' testimony, he does identify a number of issues the Commission would need to address if it decided to pursue the creation of a program for the competitive procurement of renewable energy. While I do not entirely agree with witness Levitus's opinion on how the commission should resolve each of these issues in the future, we do agree that there are a number of important issues, and I believe there are areas of agreement we can reach if given enough time to reach a solution, if the commission decides to further explore competitive procurement programs in the future.
And do you agree with the elements that witness Cersei describes as important to competitive procurement programs?
Yes, I agree that the issues of technology, eligibility, and specifications, volume of procurement, inclusion of cost cap, bidder qualification requirements, bid evaluation, and project construction are all important considerations.
Do you agree with witness Cersei that renewable energy acts as a substitute for coal and gas generation and reduces the need for fossil fuel generation?
No, I do not. As my responsive testimony explains in more detail, when solar produces energy, it reduces fuel consumption or other power purchases, but it cannot readily serve as a substitute for continuously available resources like nuclear, coal, and gas.
Do you agree with witness Levitus and witness Cersei that the commission should direct each South Carolina investor-owned utility to conduct a competitive solicitation for new renewable resources at this time?
I believe Mr. Levitus and Mr. Cersei's recommendations are premature, given the generic informational purpose of the docket and the limited amount of testimony and information that has been exchanged to this point.
And do you agree with witness Levitus's recommendation for the commission to adopt his exhibit SJL11 as a set of program guidelines?
I believe that Mr. Levitus is putting the cart before the horse, so to say. The commission's inquiry into the potential for such programs has just begun, and the stage of actual program guideline development would not happen until several crucial interim steps are complete, including a more in-depth consideration of the program framework elements raised by the parties. And by that, I mean volume, period of time, all those factors I mentioned earlier.
And instead of mandating new renewable energy procurement, what do you think would be an appropriate next step for?
In order for the commission to make an informed decision about whether programs for the competitive procurement of renewable energy should be created, it should open utility-specific dockets to investigate this question further. I agree with Dominion witness Cassis on the importance of considering utility-specific factors in evaluating the need for and costs and benefits of competitively procured renewable energy. Each utility has a unique trajectory of solar adoption that is already underway to do existing programs and commitments, and that trajectory needs to be understood and incorporated into any commission-approved new program to ensure that the new program does not merely raise the price of solar that is paid by customers.
And Mr. Brown, does that conclude?
Yes, this concludes my summary of my direct and responsive testimony.
Thank you. Mr. Brown, please answer any questions that other council or the commission has for you. This is available at this time, Mr. Chairman.
Thank you, ma'am. Dominion Energy.
Thank you, Mr. Chairman. I do have just a couple of questions, if I may. Mr. Brown, my name is Ashley Cooper, and I'm counsel representing Dominion Energy. Good afternoon.
Good afternoon.
Thank you for your testimony. I just have a couple of questions for you. You state in your testimony on page 8, and I'm on page 8 if you need to follow along. This is based on your experience and Duke's experience with a CPRE process. You describe it as saying there are significant complexities to establish programs for competitive procurement. Is that correct?
Yes, that's correct.
And you also note that creation of a program is time consuming, right?
Yes, it is.
And it's expensive, correct?
Yes, it can be expensive, yes.
So Duke pursued the establishment of a CPRE process because it had a very substantial need, and that was the fact that it identified that it had PURPA contracts where the cost were approximately $1 billion more than the forecast of avoided cost. Is that correct?
Yes, that's correct.
So my point is, Mr. Brown, let's just say an IRP identified a need to add one resource. Say it was a 100 megawatt resource. Would you launch a CPRE just because an IRP identified the need for one resource?
I would definitely not do that for a utility the size of Duke Energy, no.
Okay.
It would be worth incurring the costs of the procurement for a 100 megawatt resource.
Okay. Thank you, Mr. Brown. And I just have a couple of quick questions. I want to go back to the $1 billion overrun on these PURPA contracts. These contracts were typically 5 megawatt projects and below. Is that correct?
Yes, many of them were.
Okay, so it's under PURPA, a utility can apply to the Federal Energy Regulatory Commission to be exempted from PURPA if it can show that there's non-discriminatory access to a market. Is that correct?
Yes.
And in South Carolina and North Carolina, Mr. Levitas points out in South Carolina and North Carolina that there's no non-discriminatory access to a market.
I'm sorry, but you broke up a bit. Could you ask that question again?
Sorry. In Mr. Witness Levitas's testimony, he points out that there's no non-discriminatory access in North Carolina or South Carolina to such a market.
I don't recall that, but it wouldn't surprise me. I just don't say it.
And so the point is, though, that if one did have access to a market, you could relieve yourself of the obligations of PURPA, except for projects that are less than 20 megawatts. Is that correct?
Yes, that's correct.
Okay, so Mr. Levitas notes that had we been in a competitive market, we could have availed ourselves of this, but he didn't point out that even if Duke Energy could have availed itself of these PURPA exemptions, it still would not have solved your problem because most of your projects were less than 20 megawatts.
That's correct. They would not have been automatically excluded from PURPA. That's correct.
Okay. Mr. Brown, thank you very much, and thank you for your testimony today. I have nothing further.
You're welcome.
Carolina's Clean Energy Business Association.
Yes, sir, Mr. Chairman. We have got some questions from Mr. Brown.
Please proceed.
Mr. Brown, good afternoon. Ben Snowden here for the Carolinas Clean Energy Business Association.
Good afternoon.
Nice to see you.
Nice to see you.
First, I'll follow up on Mr. Cooper's last question about the that 20 megawatt threshold for market access under PURPA. You recall that line of questions he just asked you?
Yes.
Okay. Assuming that has any relevance here, hasn't that 20 megawatt threshold gone down to 1 megawatt with the order 872 issued by FERC?
I believe there was at least a proposal there. I'm not clear on whether it was finalized or not. But at the time when the 5 megawatt project contracts were available, it was 20 megawatts.
Understood. And is it fair to say that what I guess the company would describe as uncontrolled PURPA development in North Carolina has dropped off significantly since HB 589 was passed?
Generally, yes. There are many what I'll call legacy projects that are still in process that have PURPA LEOs that are working to become operational. But generally, other than those projects, the activity has gone down in North Carolina.
Understood. And so new permit development has really been channeled into CPRE. Is that fair to say?
Generally speaking, yes.
Thank you. So going back to the CPRE program that Duke has implemented in North Carolina, what was your role in the development of that program, if any?
I was on the team with a number of other people that were involved in drafting and negotiating with all the various stakeholders at the General Assembly on a comprehensive bill.
So you were involved in drafting the legislation itself?
Well, basically, I would provide input to our attorneys. Sometimes I'd give them red lines. Sometimes I'd just explain concepts, and then they would, in turn, provide their feedback to, I believe it was House staff. The House was leading the development of the bill. And so there was a staffer there assigned, and there were attorneys that were part of the House staff that actually were drafting the bill.
And did you also participate in the regulatory process, the development of rules for implementation of CPRE before the North Carolina Utilities Commission?
I did.
Okay. And have you participated in the administration of the CPRE program insofar as Duke has participated in it?
I have participated in the administration to a certain extent, not super involved. We have another group that does much more of the day-to-day blocking and tackling of administering the program, but I'm familiar with what they've been doing, yes.
Understood. And would you describe that CPRE program as a successful program?
Well, I think that's hard to know right now. I think that, as you noted, HB 589 was successful because we did dramatically rein back what was really sort of uncontrolled PURPA development, which was expensive. I think when these projects are online, when they're operating, we've definitely sourced them as cheaply as we can. And, from that standpoint, that's a good thing. But I think, as my testimony explained, whether customers will actually save money on these compared to other alternatives when the power is produced, that remains to be seen.
Okay, thank you. To pick up on that, in your direct testimony, you say that the benefits of a procurement from CPRE or any other procurement may or may not materialize depending on how the contracted price compares to the actual spot market price over the life of the contract. Is that right?
Yes.
Okay. But Duke doesn't actually get all its power from the spot market, does it?
Duke gets its power from a combination of things. Spot power is one, fuel that we burn on our own generation, or contracts we have. We have contracts for renewables. We also have contracts for gas capacity that we will use for third parties, that third parties own the actual gas plants. So we have a number of different things we use.
Okay, thank you. And what percentage approximately of the utilities power purchases are made on the spot market?
I don't know that number.
Okay. Isn't it true that anytime that the utility procures generation, even when it builds generation, there's a possibility that the costs of that generation might exceed the spot market price at the time of delivery?
Well, when it comes to on generation, what we do is we dispatch our units when we get close to when we need the energy, so a week out or so, let's say, based on what the relative cost of the generation is, and we try our best to use the cheapest generation that we have to lower the cost of fuel to customers. So we look at the different options we have, and we go with the cheapest we can use to the extent we can, if we're allowed to.
Understood. And is it the case that the contracts that Duke has got under CPRE allow for some limited economic dispatch of projects?
Yes, the contract in CPRE allow for 5% of the annual volume to be curtailed economically in DEC, sorry, 5% in DEP and 10% in DEC. Yes.
Okay, understood. So the company can get some economic curtailment rights even when it procures it through a competitive process.
Yes.
Okay. And going back to the utility units, even when you were able to curtail those units economically, you still have to pay the capital cost of those units, right?
Yes, the cost of the utility units are in base rates. Yes.
Okay. So no matter how the utility is getting its power on a long-term basis, there's always the possibility that it's going to be more or less economical than the alternatives. Is that fair to say? You just don't know what the future holds?
Well, traditionally, the utility would build a new unit based on a need for capacity. And it was only after it was determined that we really needed that capacity would we build a unit, and we would attempt to build the most economic unit we could based on what fuel was available. I mean, if you're going all the way back to how the system was built, that's traditionally how it was built.
Okay, understood. So you testified that the CPRE program was developed as a way of moving North Carolina away from the traditional PURPA model to the development of a more competitively driven model. Is that right?
Yes.
Okay. And you characterized the biggest benefit of that move as protecting ratepayers from what you refer to as that overpayment risk. Is that fair?
Yeah, the problem with PURPA is it's unlimited. The volume is unlimited. Whatever can be developed based on the rate that's set by the commission, that's how much you have to take.
But you previously testified to this commission that the benefits of procurement through CPRE go beyond getting renewables at lower than avoided costs, haven't you?
There are benefits of it, no doubt.
Okay. Do those benefits include enhanced operations control and those dispatch rights we talked about?
Compared to a PURPA contract where you would not have the right, where you could not demand the right to economic curtailment, the CPRE contract is beneficial. Yes.
Okay. And those same enhanced operational controls and dispatch rights could be implemented in a procurement by this commission, that's authorized by this commission, couldn't they?
Yes.
And have you previously testified that in tranche 1 of CPRE alone, that the procurement of solar through CPRE saved ratepayers approximately $261 million over the term of those PPAs? Does that sound right?
That's probably relative to the avoided cost cap you're talking about.
And you previously testified to this commission that the company supports South Carolina QS participating in the CPRE program to deliver the most cost-effective and reliable solar resources to meet the customer's future energy needs.
Yes.
And that's still true today, isn't it, in terms of your viewpoint?
Yes.
So you've reviewed you mentioned the guidelines that Mr. Levitas proposed in his direct testimony, is that right?
I quickly reviewed them. They were rather dense.
Mr. Levitas says that these are heavily based on the North Carolina CPRE structure and guidelines. Do you agree with that?
I recognize some commonalities, yes.
Okay. So assuming that these are consonant with the North Carolina CPRE guidelines, would you agree that structure has worked well so far for Duke in the Carolinas?
Well, I think it's important for the commission to understand that HB 589 created a mandate to acquire renewable energy. It was not based on what was in the IRP or anything like that. And there were some very prescribed rules about how the utility was going to source that and on how the utility would participate. And that was all laid out by statute. And then the commission created rules over the course of several months to comply with the statutory rules. So I believe in it as a program. I think it accomplished what the state set out to, accomplish. That doesn't necessarily mean that it's the only type of program that would be appropriate for South Carolina to look at.
Understood. So when you say that there were certain prescribed rules in HB 589, I assume you refer to the size of the procurement. That's one of the prescribed rules, right?
The size of the procurement, how the adjustment, the volume of procurement was adjusted based on how much other solar came onto the system. The geographic location could be anywhere in the balancing area. There was a 30% limit on utility self-developed projects that's in there. There's a wide variety of. There was a new rider created for cost recovery for this program in North Carolina. So there's a number of different things.
Okay, and there's also the statute mandates an independent administrator. Is that right?
The statute mandated an independent administrator. Yes, it did.
Okay. So those prescribed rules include the volume of procurement, the rider, utility participation, and the independent administrator. Are there other prescribed rules that you can recall that were baked into HB 589?
There was just in the competitive procurement section you're talking about?
Yes.
Okay. For example, in there, that's where it brought up the fact that we should have the ability to operationally control the solar, which is what manifested itself in terms of this economic dispatch. I'm trying to think, there's lots of other things. I'm trying to just hit on the big ones.
Okay. All right. Understood. But your testimony doesn't point out any way in which these prescribed rules or these guidelines that Mr. Levitas proposes are dissatisfactory, does it? Or unsatisfactory, sorry.
No, I just did not think. I didn't think we were at the point of talking about guidelines. I think we were. I would kind of approach this docket as we were just going to try to lay out the issues that need to be considered.
Okay. So you would characterize the purpose of this generic docket as simply gathering information for CPRE programs?
That was my interpretation of what the commission was looking for.
Okay. And not that this docket, in your view, is not for the creation of competitive procurement programs?
I think it could eventually be that. I just didn't, when I read the directive, the way I interpreted the things they were looking for, it looked like they were more looking for information. That was just our interpretation at Duke. So that's what we tried to provide.
Understood. And you characterize Mr. Levitas' recommendations as premature because you say it's too early for the commission to make a blanket determination that procuring renewables through competitive procurement is in the public interest for any utility. Is that fair to say?
Well, I guess the way I look at it is I think the commission needs to get comfortable as to what the utilities are being directed to accomplish through whatever competitive procurement program is approved. And I think once one arrives at the purpose, then you can start to talk about things like volume and guidelines and things along those lines. But I think it's important that you establish, have a clear understanding of the purpose of what you're trying to accomplish first before you start to design much of the detail of the program.
Understood. And you testify that the purpose of a CPRE program would be to meet resource needs that are identified in the IRP. Is that right?
What I testified to was that I testified to the relationship between the IRP and CPRE. And what you have to keep in mind is the IRP is a point in time estimate or plan And it's very useful to think about how the utility is going to meet its needs from its existing and future assets over the life of the forecast period. But that doesn't mean one should necessarily automatically try to go execute all aspects of the IRP immediately, because you have to understand the assumptions of the IRP to understand what you're actually going to accomplish when you go procure this competitive source of energy. And that to be very comfortable that you are willing to take a position lining up with those assumptions. I don't know how else to articulate it, but that's the way I see it.
Well, doesn't the IRP represent the company's best guess as to what the resource plans that would be most beneficial for the ratepayers are going to be?
Well, I think in the Duke IRPs that we filed, we had several different scenarios as to how the portfolio of assets and contracts can change over time based upon policy and based upon a current snapshot of economics. I think the thing to remember is that economics can change. I mean, 10 years ago, solar was not nearly as cheap as it is today. So you want to make sure that you are not getting ahead of how technology evolves and taking too large a position in one particular technology just for good portfolio management reasons. So it is its best estimate, but it is also mostly a tool to be able to show people how things change based on policy.
Okay. Well, then how should, if it's just to show how things can change, how should the IRP be linked to the decision to engage in a procurement?
Well, I think there are other reasons that you might want to do a competitive procurement of renewable energy, which wouldn't necessarily be because it can provide capacity at the hour that the IRP needs it. You may want to do it because it's a different fuel type than the other assets you have. That would be an example of why you might want to do it. It may be you may want to do it because you anticipate policy changes that are coming at us, and you want to sort of layer into it. But you need to understand what you're doing. I'm not saying you shouldn't do it. I just think it's important that all the parties understand and the commission understands exactly what position it's taking when it goes down the path of approving a program. Because it may or may not save customers money. It may diversify things. It may provide a hedge against carbon dioxide, taxes or something like that, which is that's fine. I just want everything to be clear that that's what it does.
Okay. So it's your view that whether or not the IRP demonstrates that procurement of renewables is the least cost option, there may be other reasons that would drive that would make it advisable to conduct a procurement?
There could be, yes.
Okay, thank you. But Mr. Levitas, in his testimony, does take the view that the commission-approved IRP should be the driver for any decision to proceed with procurement. Is that right?
That's my general recollection. Do you want to point to a specific page generally, yes, that's what I believe he was saying. I don't remember exactly.
Okay. So he's not recommending that the commission order a procurement from any utility now, is he?
I don't believe he's asking them to order a procurement. I think my recollection was he was asking him to consider adopting guidelines.
Thank you.
Anything else, Mr. Snowden?
Yes, sir. I'm sorry, Mr. Chairman. I'm just trying to cut out questions to streamline things a little bit. Hope you'll indulge me. I think you could probably all agree that's a worthy goal here. So, Mr. Brown, just to go back to I think what you said a few minutes ago is that even where there's not a capacity need identified in the IRP, that it may be economical to procure renewables because the energy provided by those renewables might displace more expensive generation on the system. Is that a fair characterization?
The renewables could happen. Yes, but I would say that I would look for other benefits besides trying to save money. That's just what I would do, because I don't know where the future of fuel prices and power prices are going to go. So I don't have a view that, a particular price is a price that is going to be a good price when I get there in 5 years. I just don't have that.
Understood. And I believe I recall you testifying that there is, and I believe you just said this, there is some benefit to diversification of fuel sources. Is that right?
There is. It's a tough one to quantify, just because, you have to kind of look at the total rate, the total bill of the retail customer to figure out, first of all, how much exposure does the retail customer have to fuel prices or purchase power prices for that matter. I mean, short-term volatility, which is what these longer-term contracts would hedge. And then you have to decide, is it worth the cost of trying to manage that volatility?
Understood. So it's difficult to quantify those benefits. I guess my question is, has Duke tried to quantify the benefits of that diversification?
I am not. We may have. I don't know. I haven't seen anything.
Okay. Thank you. Mr. Brown, in your direct testimony, and I'm looking at page 19, you talk about the different options for administering procurement program.
Yes.
And you testified that NCCPRE was fully administered by a third party, but this arrangement may not be appropriate in some cases or necessary where the utility is not competing directly with non-utility bidders. Do you see that?
Yes.
So when would it not be appropriate to have third-party administration?
Well, earlier in the same question, the answer, I pointed out that when we were sourcing South Carolina Act 236 for Tier 1 under that, we did that on our own, and we didn't have any. I mean, we weren't participating either. So, are you saying? I'm not sure I follow your question.
I was just asking you to explain in your view when it wouldn't be appropriate to have third-party administration. And it sounds like you said when the utility is not participating, it's not necessary. Is that fair?
Well, that's clearly, and I think there's sort of a middle road as well that I think one of the other witnesses was describing about an independent monitor. That's an approach that could be taken. So I think the commission should explore that one as well, because that'll cost less than an independent administrator, at least based on our experience.
Okay. And did you hear my colloquy with Mr. Kojak about the use of the independent administrator in CPRE?
I was listening at the time, yes.
Okay. And would you agree that that in the North Carolina CPRE program, that process appropriately leveraged the utilities' experience and expertise in evaluating projects to make the process more efficient and more effective?
No, I would say that what it did, it accomplished the goals set out in the statute, which was to have a great deal of independence. But actually, the independent administrator had its own views on how to evaluate projects. And we certainly met with the independent administrator early on in the process to share, views and best practices. But I'm not really sure that they were able, I don't think they really wanted to leverage the knowledge of the utility, because I think they were more focused on trying to be independent. Because I think that was their mandate per the statute.
Okay. But Duke did provide input on the evaluation criteria that were used in.
Yes, I mean, we did. We definitely did. I don't want to. I thought you meant like when it came down to actually evaluating the bids. That's when we really didn't have any line of sight.
Understood. That was done by the independent administrator.
Right. That's right.
Okay. But Duke's interconnection staff provided their expertise in evaluating the interconnection costs of the proposed projects. Is that right?
The transmission groups had studied the project to estimate the upgrades, yes. But they just take what's given to them, study it, and then here's the numbers back. That's how they operated.
Understood.
They know who owned which project.
Okay. Well, would you agree that that was an effective structure for administering the CPRE?
I think it was effective in terms of making sure it was independent. I think it was maybe a little bit of overkill, and it was pretty expensive to implement, but that was the way the statute read, so that's what everybody agreed and the commission agreed that's what you had to do.
Okay, thank you. So in your direct testimony, Mr. Brown, you talk a bit about the importance of interconnection studies to competitive procurement. You recall that?
Yes.
Okay. And you say that depending on the interconnection procedures that are in place, modifications may be needed to evaluate projects to submit bids into an RFP. Is that a fair characterization?
Yes.
Okay. So,
Mr. Snowden, if you would not mind,
Yes,
let's take a quick recess. I'm seeing it's 5 o'clock. We'll be back at 5:15. Good evening, ladies and gentlemen. We're back at the Public Service Commission of South Carolina's hearing in docket number 2019-365E. Let's take roll. Here in the hearing room, we have Commissioners Powers, Thomas, Belzer, and Williams, Chairman Williams, and joining us virtually, we have Commissioners Caston, Irvin, and Williams, District 1 Williams. All right, Mr. Snowden was in the middle of cross-examination. Please proceed.
So thank you, Mr. Chairman. And Mr. Brown, you'll be happy to hear that I took the break to cut some more questions. So we're almost at the end here. So Mr. Brown, I was just starting to ask you some questions about the importance of interconnection studies to procurement. In your direct testimony, you testify that depending on the interconnection procedures that are in place, modifications may be required to establish, in order to establish a more coordinated and efficient evaluation of projects that submit bids in the RFP. Is that your testimony?
Yes.
Okay, so basically what you're saying is that for an RFP to proceed most efficiently, you may need to change the interconnection process a bit. Is that right?
Correct.
And the changes to Duke's interconnection process that we refer to as key reform that have been recently approved by the South Carolina Commission incorporate changes, those kinds of changes that will be required for procurement. Is that right?
Generally speaking, yes.
Okay. And similar changes have been approved in North Carolina. Is that right?
Yes.
Okay. But Duke did the first two tranches of CPRE before key reform was approved, didn't it?
Yes.
Okay, and how did it do that?
We applied in each state for a limited waiver to the serial interconnection queue process to create a CPRE group study, which enabled us to study all of the projects that were bidding in at the same time.
So you got, in fact, got a temporary change to the interconnection procedures for the sole purpose of doing that cluster study required by CPRE. Is that right?
Yes.
Okay, thank you. How long did it take tranche one to run from the time the bid window opened till contracts were awarded? Was it about 9 months?
That sounds approximately right to me. I can't remember exactly, but that sounds reasonable, yes.
Okay, understood. And how long after that does Duke anticipate it would take, or did it take, for the projects that were selected to complete the interconnection process?
I think they're coming in over time, but I believe they will be, almost all of them will be in service, certainly by the end of 22, but it might even be earlier than that. It might be the middle of 2022, that they'll be in service.
Okay.
I don't have I have not gotten a recent briefing on exactly when they're going to be online. That's
Okay.
my general impression.
Middle end of 2022. Is that what you're saying?
For all of them. Some of them are coming on earlier than that. So that's
Okay.
kind of like the latest one might be that late, yes.
Understood. And is it your understanding that none of the projects that were selected in tranche one had any very significant network upgrades that required extensive construction?
That's correct.
Okay. So, and I'm sorry, do you recall when it was that contracts were awarded for tranche one?
I do not remember exactly. No, I don't want to guess.
Okay. I should know this as well. Was it in 2019? Is that right?
Yes.
Okay. I'll say so. Even without significant network upgrades, you're looking at 2 years plus from the time that contracts were awarded until the time you're looking at projects going in service. Is that fair to say?
For the last ones, I want to emphasize that because, there are multiple projects, and so some of them were able to come on earlier depending upon how they could schedule the crews and the work done to get them interconnected. So, but it does take time, just because there are a lot of solar projects trying to connect in the queue.
Understood, understood. So, but realistically, depending on the nature of the upgrades required, even without extensive upgrades, it could take 3 years from the time that a fully baked RFP is opened until the projects that get selected go into service. Is that fair?
It could.
Okay. And that's not counting the amount of time that it takes to actually set up the RFP process itself.
Right.
Okay. So if the commission were looking at, or if either of the utilities, any of the utilities in South Carolina were looking at procurement, even 5 years out, wouldn't it make sense to begin laying the groundwork for that, those processes now, rather than waiting?
Yeah, I would say to begin to start the process to develop all the details of the program that you're going to prosecute. Yes, you could start it pretty soon.
In your rebuttal on page 7, and this is a response to Mr. Levitas' testimony about the investment tax credit.
Yes, let me get there. Okay. Yes.
Okay, are you with me? You say you disagree with Mr. Levitas' testimony that a solicitation is needed as soon as possible to take advantage of the federal investment tax credit. Is that right?
Yes.
Okay, and that's because Congress extended those tax credits by 2 years. Is that right?
They extended I think they extended the 26% by 2 years. Yes, and I think they extended the safe harbor till the end of 2026.
Okay, but the ITC steps down from 30% to 26% to 22% and to 10% over time. Is that fair?
Right, but what that means, what the safe harbor means, is that if you commence construction, and I think it's really only something like 5% of the total project, during the period of time that the 26% tax credit is available, which is today and all of next year, you have until the end of 26, I believe it is, to actually place the project in service to qualify for that 26%. That's the safe harbor.
Isn't it the case the safe harbor is 2025 and not 2026?
Oh, maybe I could be wrong. I thought it was 26. I thought they extended it by 2 years, but you might be right.
Well, do you agree that a higher tax credit has the potential to allow solar developers to deliver energy to ratepayers at significantly lower cost?
I think, yes, I think the tax credit will lower the cost, yes.
So given the timelines that we were just discussing, given the interconnection timelines we were just discussing, wouldn't a solar project need to be under contract in the next year, potentially, in order to have a chance to achieve commercial operation by the end of 2025?
By the end of 22, you're saying?
2025. Well, yeah, sort of contract.
The contract. End of 22 or midway through 23 would give you a really good chance of being in service by the end of 25.
Okay. Thank you very much, Mr. Brown.
Contract, yeah.
Okay.
Sorry.
Okay. All right. Thank you very much, Mr. Brown. Those are all my questions.
Cypress Creek, Exoplexus, Southern Current.
Mr. Chairman, thank you. We don't have any questions of this witness, but I do have a request to the chairman that I'd like for you to entertain after this witness is concluded.
Sure. Johnson Development Associates.
Mr. Chairman, Johnson Development doesn't have any questions.
Thank you, sir. If you're not speaking, if you could mute your microphone. We're getting a little background noise in the hearing room. South Carolina Coastal Conservation League and Southern Alliance for Clean Energy.
Thank you, Mr. Chairman. We don't have any questions.
Office of Regulatory Staff.
Thank you, Mr. Chairman. This is Chris Huber for ORS. We do not have any questions for this witness. Thank you.
All right. Commissioner questions for this witness?
Mr. Chairman,
Commissioner Thomas.
thank you. Mr. Brown, I have just one question for you. So I believe I heard you say that there were, due to the volume of the responsive answers that were received and the limited time that you had to review, that you did not get an opportunity to maybe review and you didn't get an opportunity to review to the extent that you wanted to. And so my question is, if you come up with any other thoughts or ideas that you think that we should be aware of, given that a little bit of time has passed.
Do I have anything else to add? Is that what you're asking?
Yes, sir.
No, I don't think I do. Other than what I've sort of covered in my direct and responsive testimony so far.
Okay, very good. I appreciate it. That's all I have.
Any other commissioner questions? All right, hearing none, any redirect?
Chairman Wade.
Oh, Commissioner Caston, I'm sorry, sir.
I'm sorry, I couldn't hit the button. I hit every one but the right button.
All right,
Mr.
please
Brown,
proceed.
I apologize for delaying this. Can you hear me okay?
Yes, I can hear you. Yes.
Okay. Just briefly, I'm going to try to sum up in a broad sense what I think I understand from your direct and responsive testimony and your responses today. PERFRA policies created a distorted market, you said, for solar development, and the pace of the qualified facility, the QF, unabated would pose serious risk of overpayment by utility ratepayers, correct? Is that?
Yes, at the time, yes.
So existing PERPA framework is not in best interest of non-participating customers? Is that what you're saying?
Yeah, the North Carolina PERPA framework at the time was, I would say, overly beneficial to solar developers at the time, and caused a lot of solar to come onto the system, and which turned out to be expensive for customers.
And how about for South Carolina?
South Carolina had different rules, and it did not have the same PERPA policy that North Carolina had prior to HB 589. So we did not have to provide the same tariffs that we had to provide in North Carolina, in South Carolina.
Okay. So you say from 2012 to 2017, the PERPA framework resulted in contracts that cost about $1 billion more than the current forecast for avoided cost over the remaining terms of contracts. Is that true?
Yes, that was the number at the time. Yes, it actually might be larger now.
And I think relative to a question, and to be honest, I don't remember if this was a question in your testimony or one that was asked of you in the hearing. Do you believe that CPRE is beneficial for customers? I guess I'll leave that. Do you believe that CPRE is beneficial for customers?
CPRE is clearly beneficial to customers compared to the legacy PERPA framework. And I think that's the way it should be viewed. Because it has been successful to drive down the cost of solar compared to the old framework. And we've been able to get contractual rights in these contracts that are better for the customers than we could in the old PURPA framework.
Okay. And I think you said in your direct testimony, I think, that diversification benefit is real, but the value of the benefit is not easy to quantify.
Yes.
And in a nutshell, it's not easy to quantify because,
well, the way it depends how much you end up, unfortunately, it depends on how much you end up paying for that diversification benefit. So, for example, you know, if you were to pay, I'm going to make up numbers here, but just to demonstrate the concept, if you were paying, you know, only $5 a megawatt hour more, and you were reducing your fuel volatility by 5 or 10%, you know, that might be a good use of that $5. But, you know, if you're paying $50 more and you're only reducing it by 5%, maybe it's not worth the reduction in the risk because you're paying such a high premium. And this is one of the difficult things that, you know, we all collectively have to struggle with, is what is the right balance between using these alternative fuel sources and alternative contracts to reduce risk, but you're still potentially going to be paying a premium for those contracts. And that's where it's judgment. And I think the most important thing is to make sure you just don't go too big on the diversification benefit. That's probably your safest bet. Does that help?
okay. Yes, sir, it does. And I think you said, I think this is a paraphrase, the benefits projected at the time of contract may or may not materialize because it is impossible to know the future of the spot market price of fuel.
That's accurate.
All right, IRP can and should be the utility's plan to meet projected capacity and energy need for a forecasted period. Do you agree with that?
Yes, it is. It's a plan.
The IRP can and should determine most appropriate energy source based on a clear understanding of assumptions, I guess the drivers. Can you kind of elaborate that a little bit?
Yes, I think sometimes we can focus on the results of the modeling, you know, how much solar is coming on or how much gas is in the plan or what have you, instead of what are the underlying assumptions that led the plan to select those resources. And I think it's important that we have a clear understanding of those assumptions and of the risk of the assumptions, or of how some of those assumptions may go a different way, and you may end up with too much solar or too little solar. I mean, that's also possible because, you know, you decided not to buy any solar because you were too afraid of locking in any long-term contracts, which I'm also not a proponent of no long-term contracts. I don't think that's the right mix either. So that's what I meant by that.
I understand. So would a good example be, and correct me if I'm wrong, if it's a compliance issue that would cause renewables to be a favorable choice, that makes sense, do it. Or a need for dispatchable energy, that would be a different thing. Or is that what you're talking about? Okay.
That is precisely what I'm talking about.
And I'm not trying to pick a fight here with you, and I apologize if I'm getting ready to butcher Mr. Levitas. I don't know how to pronounce it, but if I'm understanding, I guess, some of your concern, and pardon me, because I'm trying to plug in this phone here, if you'll excuse me, because I'm about to down. Okay. the two major points I saw, points of disagreement, I guess, is one, you say you feel his testimony goes beyond the scope of this hearing. Is that correct?
Yes, I felt that after looking at the topics that the commission wanted to cover. It just looked to me to be more of an exploratory gathering of information and understanding of how things work rather than suggesting a particular structure.
And you disagree with the assertion that all utility generation development should become a competitive process and the utility not have the ability to build their own. Is that correct?
I think that there can be good reasons why you would want the utility to own some of the generation or most of the generation going forward. I think first and foremost, the Public Service Commission has much more say over what happens to utility generation than it will on a non-utility generator, especially after the contract term is up. And so I think that I appreciate Mr. Levitas' position. I think it's a bigger question about what is the right mix of utility-owned resources and third-party resources to have a reliable system that works under all scenarios.
I understand, and honestly, I'm not trying to throw gas on the fire. There's just a lot of information there, and I'm trying to get as good a summary as I can without making you go through all that again. But I appreciate it, and thank you very much for taking the time.
Thank you. You're welcome.
Redirect.
Mr. Chairman, recognizing the hour, this will be very brief. Mr. Brown, you and Mr. Snowden had an exchange about the timeline associated with procuring new renewable resources through a competitive procurement and the length of time that process takes. Is it your understanding that it is the contract portion of that process or the interconnection portion of that process that is primarily responsible for the lengthier timelines that Mr. Snowden was talking about?
You said you were breaking up a little bit, but let me just make sure I understand. You were asking, is it the contracting process or the construction and interconnection process? Those two processes?
That's correct.
I would say generally the interconnection is the wild card on a project in terms of how long it will actually take. So there's greater variability there than there is on the contracting process.
So if a project was to win an award under a CPRE program and it was toward the end of the interconnection process, then the timelines associated with that would be much shorter in time than, say, a project that was just beginning the interconnection process and received an award under the CPRE process. Is that fair to say?
Yes, that could be true. Yes.
And so if that logic follows, then it may not be the responsibility of the program for the timeline associated with procuring renewables, and instead the virtue of where various projects are in the timeline associated with interconnection. Is that fair as well?
Yes, that's true.
And one other topic, very quickly, you and Mr. Snowden had an exchange about the extension of the investment tax credits. What opinion on the likelihood for potential additional tax credits or other technology changes that could lower the cost of solar in the future? Is that a possibility?
Attorney Doolin, I hate to interrupt your redirect. I'm not sure if there's an issue on our end or your end, but we're hearing every other word, and I want the court reporter to be able to record your line of questioning accurately. So I don't know if we just need to pause for a second or if there's anything you can do on your end to address that issue.
Please give my apologies to Ms. Wheat. Is this any better? I just moved, sorry you have to see my face a lot closer, but I just moved a lot closer to the microphone. Does that help at all?
It does. Thank you.
I apologize. If it's okay, I'll ask that question one more time. Mr. Brown, you and Mr. Snowden had an exchange about the investment tax credit and the extent to which near-term procurement would be helpful in obtaining those investment tax credits. What is your opinion about there will be future policy changes that could in additional tax credits or other technology changes that could result in lower costs for solar in the future?
One of the things that I do in my job is I also work with our federal affairs people who are working on renewable and clean energy policy at the federal level. And there are a number of bills that are in process, some of which have already been introduced, that are designed to further renewables and other clean energy sources at the federal level. So it remains to be seen whether they will pass, but I certainly think that there's the potential that there will be some federal policy that will be supportive of solar and renewables and other clean energy going forward, in addition to the tax credits.
Thank you, Mr. Brown. Mr. Chairman, that's all I have. I appreciate your patience and the court reporter's patience, and this has been a good test run for me, and I'll sit this close next time. Thank you.
No worries. Anything else for this witness? All right, we're in recess until 12 p.m. tomorrow.
Thank you.